What do you mean? But um oh okay. Um okay. Um log in. You log into this and
Log into
there's
it online.
on Chris's
Okay.
and there's a link for the
Okay.
YouTube. So click on it and what?
So are you hands-on
Yeah. Wait, what's that? Oh my gosh, I'm so
Board of Ethics Commission to order. Will please have a roll call.
Where's the sheet? Commissioner Akers,
Here.
Commissioner Carbajal, Commissioner Cummings,
Here.
Commissioner Gates,
Here.
Commissioner Gilzine,
Here.
Commissioner Grant,
Here.
Commissioner Lesnoff,
Here.
Commissioner Meggs.
Here.
We have a quorum present.
Thank you. And let's go ahead and pledge allegiance to our flag with Commissioner Gilzine.
So I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let me go ahead and make some preliminary announcements. First of all, we are attempting our own live stream today, so be advised that that is occurring. There are cameras. This is a first attempt of its nature, so please be patient with us. We may have to stop if things go wrong and try to recalibrate. There's some housekeeping announcements. The Agency for Healthcare Administration graciously lets us use their facilities. Please respect their rules. Have no food or beverage other than water in the room. Please silence your cell phones. Anyone addressing the commission, please speak up so our recording equipment can pick you up properly. And fellow commissioners, please speak into the microphone so you can be heard. Since we're operating under special circumstances, I ask that you be brief and concise as possible in your questions and comments. Pursuant to law, members of the public have the opportunity to input on matters before the commission, other than cases in which we act in capacity. This means the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. Okay. She didn't have to vote. She comes back and we'll see. Before we go into approval of the February meeting minutes, I wanted to move the agenda and move the item regarding process up to the top, because I wanted to offer this to the commission, and we would, if you're okay with it, we'll proceed with this issue. We're all aware that the commission does not have formal rules by which it conducts the commission business. It loosely follows Robert's rules. One of the things that I have noticed since being on the commission is that a motion is made, then there's a discussion of the motion, and often during the course of that discussion, a lot of perspective comes to light that often changes the perspective even of the people who made the motion. Then we are in the position of tracking the motion, getting new motions. I would propose to you that, as in other types of hearings, what is before us is typically an opinion or an advocate's recommendation or something that's very clearly before us. And I would ask that we entertain discussion prior to a motion with the understanding that it is the presentation that is before us. So that way, once a motion is made, we can discuss the motion again, but there may be more clarity for the commission prior to motions. And I wanted to put that before you, get your thoughts. I'm certainly not going to impose that on you, but I wanted to see if you were okay with proceeding in that manner. Are there any objections to proceeding in that manner? Anyone? Thank you, and thank you for consideration and indulgence. Let's go ahead and have approval of the minutes. Hoping there's no need for discussion, do I have a motion?
Second.
We have a motion by Commissioner Gates, second by Commissioner Gilzine to approve the February 5th, 2021 minutes. All in favor say aye. Aye. Any opposed? Show that adopted. Our first matters for consideration of final action are three joint stipulations. Number one is case number 19-154, R.E. Belden. Are there parties or counsel here to identify themselves for the record?
Richard Pettis on behalf of Mr. Belden.
I'm Madam Sanders, I'm the complainant.
Thank you. We have before us a proposed stipulation between the commission advocate and the respondent. After considering all the material and presentation of the parties, the commission may go to approve or reject the stipulation. Complainants have the right to comment in writing on the proposed stipulation. We have not received any comments on this proposed stipulation. Ms. Hadley, you are ready.
Respondent served as the tax collector for Hillsborough County. He left office on January 4th of this year. The commission found probable cause to believe that he violated sections 112.3136 and section 112.3132 of the Florida statute. Through settlement discussions, the parties have come to an agreement. In the stipulation, respondent admits that he violated section 112.3136 and agrees to the entry of a final order recommending a civil penalty of $4,000. In addition, respondent admits that there is probable cause for a violation of section 112.3132, but the parties believe that it would not serve the public interest to pursue that allegation and request that the commission take no further action on that allegation. We respectfully ask for the commission's approval of the joint stipulation.
Thank you. Are there questions of Ms. Hadley? Is there discussion on the joint stipulation? Commissioner Grant?
So I know the parties have agreed on this. That doesn't make it altogether right. In this case, unlike, not unlike a number of others that appear before us, is one that was politically motivated. And Mr. Belden, and I have some personal knowledge because I live in the same community. Mr. Belden did not run for re-election. He's in very poor health. You may recall he appeared before us a couple of meetings ago. He came in on a walker, and he's not in good health, and therefore stepped down at the conclusion of the last term. This man has done some incredible things. He's recognized in the Tampa Bay community as being one of the top leaders. And it starts with a complete makeover of tax collector's office. He's modernized it. He's brought it into the 21st century. You ask anybody and they will tell you what a pleasure it is working in this office. He has helped a lot of people. And this case arises out of somebody saying, hey, can you find it? Try to help somebody. And it got twisted into a conflict of interest situation. I was not happy with finding probable cause, but that was the action of the commission. And now, his going away present, after a lifetime career of excellent public service, is to go out with an ethics violation and pay a $7,500 fine. And I just can't agree with that. I admit, frankly, he agreed to this simply because due to his health, he just wants to make this thing go away. And he's not in good health, and so he agreed to a stipulation which I'm sure he really doesn't agree with, but it was a way to get the monkey off his back. And I just think it's almost draconian to find he violated the ethics laws, because this man's been straight as an arrow for years. And secondly, to pay one of the highest fines I've ever seen in this commission pay, or required to be paid, $7,500. I'm just very torn about it, and I'm very sorry about it. The commission may feel, well, if the parties agree to a stipulation, then we don't need to stick our nose into whether it was right or wrong. If that's what you want to do, that's fine, but that's not what I want to do.
Is there any other discussion? I've been reading the wrong file. I thought the penalty was $4,000, not $7,500.
It's 4,000.
4,000.
When I read it came up to 7,500. Maybe that was changed, but still $4,000 is a terrific amount of money for a rather nebulous accusation.
Is there any other discussion? I will simply say that although we see actions come before the commission often that may be politically motivated, those are, they still may or may not be justified allegations. This was found with probable cause, and they've reached an agreement. So I will support the recommendation. Commissioner
Would
Anchors?
you entertain a motion?
Yes,
If
ma'am.
so, I move the approval of the joint stipulation.
Second.
We have a recommendation to approve the joint stipulation. Second, and is all in favor say aye.
Aye.
Any opposed?
Nay.
Show the motion. I mean, the joint stipulation. Our next case is 19-158, Emery Pardee. Will the parties or their counsel please identify themselves for the record?
Paul Hawks, on behalf of the respondents.
And also Mark Murray, attorney on behalf of the respondent.
Before we proceed further, I just want to acknowledge that I know Paul Hawks from a professional relationship, and though I don't need to make disclosure, I'm going to and let you know that that should have no bearing on my analysis or assessment of this joint stipulation. Ms. Hadley, you are all right to proceed.
At this time, I bring before you a pre-probable cause stipulation. Basically, in advance of this commission making a determination about probable cause, the respondent has agreed that he, and acknowledged that he violated the law and has agreed to enter into a stipulation. He served as the supervisor of elections for Madison County. He is no longer in office. Again, he's agreed that he violated section 112.3136 by using his position to arrange for the issuance and or receive salary advances above and beyond the statutorily mandated salary of county supervisors of elections. He has reimbursed those salary advances. As a matter of fact, he paid a little bit more than was calculated by an auditing firm. We ask the commission to accept the respondent's pre-probable cause stipulation that he violated section 112.3136 and impose a civil penalty of $4,000 in public censure and reprimand.
Are there questions of the advocate? Commissioner Gates.
Thank you, Madam Chair. Ms. Hampley, did Mr. Hardy return the money that you took? Did he return that money before or after the FDLE investigation?
It was after.
After the investigation. We know what Mr. Hardy's current place of residence is.
I do not know that.
Maybe we can inquire from his counsel later. Did FDLE bring any criminal charges?
I don't think so, but perhaps the investigator might be able to confirm.
No, they did not, sir.
Why Why did you recommend $4,000?
So with pre-probable cause stipulations, I take into account that we have someone who did not, who readily accepted their wrongdoing. And you take into account that this is coming before the commission's having to make a long, maybe tedious determination about probable cause. Just with any settlement negotiations, especially with pre-probable cause, I just take into account that this person is readily admitted. And while if this had been after, I would have asked for more, to be honest with you. But in looking at what I've had in the past, and I don't think I've ever had a case exactly like this, but in looking at other numbers I've had in the past for misuse cases, I thought with pre-probable cause that the 4,000 was a fair amount to recognize the actions he took, which were in violation of the code of ethics, but recognize that he readily agreed to the violation and readily agreed to do a pre-probable cause stipulation.
Madam Chair, but did I understand in answer to a previous question that he readily agreed only after FDLE investigated and found out that he committed a violation?
I can only talk about when the case gets to the Commission on Ethics. So when it got to the Commission on Ethics and it was time to move forward on the advocate's recommendation and accept what happened regarding the code of ethics, he readily agreed that he violated the statute.
Madam Chair, when it's in order to debate this rather than ask questions, I appreciate the chance to do this.
Any other questions for the applicant?
I do, Madam Chair. Could you remind me, what is the maximum penalty under what?
The maximum penalty for each allegation is $10,000, and that's under section 112.317 of the Florida statute.
Thanks.
Any other questions for the applicant? Thank you, Ms. Hadley. The respondent.
I think it's important to point out that, and I think FDLE can verify this, the respondent was completely cooperative. He subjected himself to answer any questions that they had. He readily provided documents. I think he was cooperative in the investigative stage with the advocate. He promptly repaid the money that he had advanced himself. Now, I realize it's not an excuse, but he thought that it was permitted based upon some misinformation that he had received from other individuals about how his office budget worked. And he has, I think because of his cooperation, his ready admission that he in fact violated that the fine is appropriate. That was the concern of the commission.
And if I can interject, we can double check with the investigator, but I do believe I think he paid back the money after the audit. There was an audit answer that said he owed this amount. I didn't think it was after. He paid it back before the FDLE investigation.
And then the auditor referred to that.
Correct.
I think that's an important issue for us to understand when the repayment occurred.
Through the chair, that is correct. As soon as the audit was done and it found out that he had been paid money in advance, he got that money and paid it back to the county.
Before he was.
Correct.
Are there any questions of the respondent? Commissioner Gay?
Just a quick detail. What is his current address?
As far as I know, he's still in Madison County. I don't know if he's
Not a resident of North Carolina?
His brother has a place in North Carolina, but I don't know that, I've never heard that Thomas had a place in North Carolina. But again, I cannot say for certain.
Oh, it's okay, thank you.
Any other questions for the respondent? Thank you. Discussion. Commissioner Gay?
I yield to Commissioner Minns.
Commissioner Minns?
Thank you. You know, I spent a little bit of time in prosecution,
had this case come in the Second Judicial Circuit, when FDLE came to our office, I would have agreed to prosecute this defendant in criminal court for theft and public misuse of his office and official misconduct and several other things. I would like this commission to know that the state attorney who did reject the prosecution has now been indicted for bribery and numerous counts of misconduct. And there's a new state attorney in town because that one was arrested, I think, out in Arizona on federal charges of taking bribes, numerous bribes, I think several counts. And there's a new state attorney, and maybe FDLE ought to take the case back to the new state attorney in the Third Judicial Circuit to see if they're interested in prosecution. I could not accept this. I know I say things sometimes that are not appropriate, and I'm about to say one, I think, but I have heard over the years as a prosecutor that there may be some people out there that need killing, but there's nothing out there that needs stealing. And this was stealing from by a person that was in public trust. And I could not accept this stipulation. I think you ought to get the maximum, and I think you ought to be criminally prosecuted for it. It's just wrong.
And just to reiterate, for the commission, it should be those items that are in the report of investigation, the joint stipulation, so other issues should not be part of your consideration in whatever actions we choose to take today on this joint stipulation. Commissioner Gibbs.
Thank you. Commissioner Meigs said it as usual better than I could have. If the chair would just indulge me, these violations, according to the information provided to us by the commission, began to occur in 2014. And the respondent took 10 months of salary, $17,000, and he took the money from a small county that didn't have any money. It's been said here today about his counsel that he was advised that this was proper. I should have asked, and I didn't, and I apologize. Who in the world advised him it was proper and under what authority? Because I'm not a lawyer, but I've been a public servant for a lot of years. This is theft, stealing public money. We just concluded a case that had a lot of variables in it that we don't need to back over, that Senator Grant mentioned. We concluded it by fining someone $4,000, and here we go. Finding somebody who stole money as a constitutional officer, supervisor of elections, no less, and stole it from his small county, and we're going to, under the stipulation, fining $4,000. Madam Chair, this matter was referred to us by FDLE on September 2019. The violations began to occur in 2014. We've had 3 U.S. presidents since this matter first began to surface its ugly head. A long time has occurred since this matter was referred to us. This gentleman was still a constitutional officer of the state of Florida and of his county at the time this matter was referred to us, and had more than a year to go in his term. And he was allowed by apparently the flow of activity or inactivity on this commission to continue to serve as a constitutional officer for more than a year
after the Florida Department of Law Enforcement had already concluded to refer this matter to us because of obvious theft of public funds. So I don't know if I'm more upset with Mr. Hardy or I'm more upset with us. Perhaps there are reasons why this matter lagged and lagged and lagged and lagged. When I am with Mr. Meggs and Commissioner Meggs on this matter, I can't vote for a stipulation to allow this man who could have been removed from office if we taken action in a timely fashion, if the governor would have chosen to remove him, who could have been given his comeuppance at a time when that would have really mattered, when the sanction would have really mattered, because there he was still a public figure in his county. But we chose, for one reason or another, we didn't do it. Didn't come up. And now we're going to fine him $4,000. And according to the information provided to this commission, he's been working on a house in North Carolina. I wish him well with it. But out of our jurisdiction. So I'm going to have a hard time. I'm going to vote no on the joint stipulation. And at the time that the chair would entertain such a motion, now or at some other point, I will move the substitute motion to substantially increase the fine, just as Mr. Meggs wanted to do. Thank you, Madam Chair.
Thank you, Commissioner. My understanding is if this is rejected today, then it will move forward to probable cause. Is that not correct?
If I might, through the chair, if the stipulation is rejected, then the posture of this matter, there'll be a probable cause consideration today on the matter, and if probable cause is found, then the parties can propose a new stipulation if they desire, or the respondent can ask for a trial at the Division of Administrative Hearing.
Madam Chair, may I ask a question?
Commissioner.
I just want to make sure I understand. Is this joint stipulation not amendable by a vote currently?
No.
So it's either
No.
up or down. We can't amend it.
Correct. Commissioner Wall.
Thank you, Madam Chair. So let's understand, the maximum fine that we can impose is $10,000. Is that correct? And then we have to go through a hearing, we have to do that. So the idea would be that we're accepting this as a settlement in lieu of going forward. So I support the joint stipulation. I think that that's part of the process. We didn't have to go forward with a lot of other things that we don't have to. I don't know anything about this gentleman or anything, but I think that our staff has done an admirable job.
And just to reiterate, the relevance is what's in the reports in front of us. Is there any other discussion before? I know Commissioner Gates has requested to make a motion. Is there discussion prior to that? Commissioner Akers.
So although I don't disagree with the severity of the offense underlying this stipulation, I, as a lawyer, when I prepare a settlement agreement that is a hard negotiated agreement with another lawyer and have to go get the judge to approve it, I don't know that I've ever had a case in which a judge hasn't approved it, because the judge usually appreciates the difficulty and the complexities and the unknowns and the nuances that went into the negotiation of that final agreement. I can't say that about plea agreements. I don't have any experience in the judge's approval of those plea agreements, but I think in the analysis of resources, the reasons that this commission hasn't previously acted, or the reasons that the state attorney did not act, there are a lot of unknowns in that. And so for that reason, I defer and rely on the agreement that two lawyers came to who know the most about their cases and most about their clients. And for that reason, I feel more obligated to honor that which I don't know that has been negotiated, I think, in good faith to come to this agreement before us. So that's why I would support the joint stipulation.
Is there other discussion before I ask for motion?
So just, Madam Chair.
Yes.
If we reject this because we wanted a stiffer penalty, ultimately what would happen?
there would be a probable cause hearing immediately. If we found probable cause, they could agree, the advocate and respondent could agree to a stipulation, but if they don't, it would go to DOA. Assuming we found probable cause.
Question, Madam Chair, as to Commissioner Gilzean's question. So that I understand this, if probable cause, if the joint stipulation were rejected today,
Yes.
we would go to a probable cause hearing
Now,
immediately. If we found probable cause, could not the lawyers now or between now and the time of the next commission meeting arrive at another
yes, yes, they
joint
could.
stipulation without the matter going to DOA?
Yes, yes,
Conceivably?
absolutely, yes.
Okay, thank you very
If I
much.
didn't say that, I absolutely meant to.
I apologize, man, thank you.
All right, does anyone have a motion? Commissioner Gates.
Madam Chair, I move that the joint stipulation not be agreed to.
Second.
We have a motion to reject the joint stipulation and second by Commissioner Gilzine. Is there any further discussion there? Anybody else who wishes to speak regarding the issue? Commissioner Waldron.
Thank you. I'm opposed to the motion. I think that that's the whole concept behind the settlement stipulation, is that we avoid moving forward. The best we can accomplish is to delay this and another $6,000 for a fine, which we don't have control. Certainly they can decide that our staff and their counsel, whether they want to come back and offer more money. I don't know what the real process would be, because I think that once we rejected it, it's not, I guess we could possibly bring it back procedurally today. I don't know that that's really appropriate. I think you'd have to bring it forward again in the next meeting. So we delay it even further. I don't know anything about this gentleman at all. I take to heart what Commissioner Gates and Commissioner Meggs has said. It doesn't sound like somebody I'd like to hang out with or do business with. And it sounds like, not somebody a lot of people want to do business with. But that being said, that's not what we're here for. And that's why I agree with Commissioner Rankers. Our job is just to look at what we've got presented in front of us. We have no idea why the state attorney didn't press charges, but that's not our role anyway. So I think it's appropriate that we move forward, we accept the joint stipulation.
Any other additional discussion? All in favor?
Madam Chair,
Sorry?
just a final comment, if I may, on my motion, and that is that I take the comments of my wiser colleagues to heart. But I also think that the role or value of this commission is in its moral suasion. What message do we send to other public servants, to other elected officials, to other people who could reach into the public till? And the message could be, if you take $17,000 beginning in 2014, by my reckoning, if you would have put it on your American Express card, this gives you a much more favorable rate of interest here at the Commission on Ethics than if you would have simply put it on your American Express card instead of stealing it. So I think the moral suasion, the moral message coming from this commission needs to be, we don't put up with stealing money from the public till. And that's why with reluctance and with deference to the lawyers who worked hard on an agreement, we're the ones who still have to put our names beside that agreement and say, this is the message for the people of Florida. And it's a message I cannot send, and hence I will support my motion.
Okay, very well. All in favor of the motion to reject the joint stipulation, say aye.
Aye.
All opposed? No. That motion is approved. So we will now move into probable cause.
Yes.
Yes.
Procedural question.
Okay.
I mean, maybe I should have known since I've been on this commission lots of years at different times that we would do this. I just don't recall being in this posture. Is there a way not to move right into probable cause and to take this up at a later time if the commission agrees? Just in terms of, I don't know if everyone's prepared to evaluate it as a probable cause case. I think they are completely prepared to evaluate it as a probable cause case. I'm partly just interested in that's not what I thought was on our agenda today. And would we want to consider postponing it? It's more properly on the agenda, or is it required procedure?
I think we probably could, however, the referral, order of investigation, report on investigation, advocate's recommendation, all these items are before us. Yes.
I thought we did probable cause in executive session, and those are confidential until the determination is made. What changes it here that now all of a sudden we're in public for this? And I think that if I understand correctly, most times the respondent is always given an opportunity to respond to the pleadings, in essence. In this instance, I guess they could have responded, but they may have thought they had a settlement.
Well, they waive, Chris, their confidentiality when they.
If I might through the chair, there's a standard line in the stipulation where the respondent waives confidentiality, and that's why it's now on the public agenda. So once waived, they can't go back into the executive agenda. And the reason this feels kind of odd is I can't ever recall when a pre-probable cause joint stipulation has ever been rejected over many years before today, based on, the notions of settlement. But the notice to the people is always that if it's rejected, we'll go into the probable cause consideration. And that, would help move it along, and everybody's here. And that's why we put all these different items in the materials you get. So in case the thing falters on stipulation, if we can't go forward on probable cause consideration.
And I am willing, if the commission wills it, to delay. I would not support that, but the commission.
Madam Chair.
Yeah.
Madam Chair, could I perhaps propose something that we temporarily postpone past this and allow our counsel to speak to their counsel and see if there's any kind of a revised settlement that they might entertain? Along the lines of what Commissioner Jason suggested.
Chris, do you want to?
If I might, through the chair, that's typically not been the practice, although when I used to do criminal law and I saw things going south, I would often go out and talk to the assistant state attorney, or when I worked with Mr. May, go talk to the other side. And, if they want to negotiate something else and they can get it done on paper and they can bring it back to you before the public session ends today, there's no legal bar to that. If something else is negotiated, I would like to hear what the advocates think about that, though.
Melody, I will tell you, I am fairly uncomfortable with that proposal, only because they could go and start working on something and then it doesn't happen, and then we're delaying even further. And to Commissioner Gates's point, this has gone on for a long time, so I don't know that there would be any guarantee that we would get something back before. But
Madam Chair, if I understand correctly, I just want to make sure for future already. The maximum we could go to was $10,000 today. So there's $6,000 separating us from settlement today versus if we find probable cause, then it goes to a negotiator. Is that correct?
Yes.
So at that point, it's going to be the same $10,000, right? And everybody will have to do all the work and go forward with it. We only want to see what's I guess the lawyers once again are the ones making the money.
They could do that after a problem cause here. $10,000.
Through the chair, there is an additional possible penalty in addition to the monetary penalty. Public censure and reprimand is possible. Do you already have that in there?
Yes.
You do? Okay.
Commissioner.
I won't beat this very much longer.
Okay.
I just would say that I accustomed to going to a meeting where you're living in the Sunshine State where you're on notice of what's to be considered, whether you're a member of the public or a member of the decision-making body. And I would just say I'm very much on notice of the probable cause joint stipulation, not on notice. The proposed joint stipulation does say that in the event that it is not approved by the commission as written, this document shall be of no purpose and effect and should not be deemed an admission by respondent. But it doesn't go on to say that it could then turn into an immediate probable cause hearing for which the people that are here are not necessarily prepared.
Wait, I'm sorry. It does say in the notice that was sent out on February 23rd.
Dang, I hate people.
There in bold, it says, please note that should the commission reject the proposed stipulation, we will then immediately proceed with probable cause hearing at the March 5th, 2021 meeting.
But that's in his email, that's in the email notice?
That's in the mailed notice that it was sent to inform the respondent, complainant, me of today's meeting.
Yeah, I'm pretty sure the respondent was prepared, just not me.
Well,
And I'm sorry, it's a referral in this case, not complaint.
I'm done, I'll defer.
I will say this was, we did receive the other information in the executive session notice prior to being moved to public session. So I feel like we've had the information before us for quite some time. But if you want to make a motion for this one, we'll consider it. All right, let's go ahead and proceed with probable cause hearing. Ms. Hadley, you're right.
One of the councils had stepped out of the room. He was trying to contact his client, so I can still proceed if that's okay.
Let's postpone until we'll take up the next matter, but we will come back to you before we leave this general item. So let's go ahead. We're going to TP this now until after the next case, which is item number C-210, R.E. Nixon. Will the parties or their counsel please identify themselves for the record?
Good afternoon, Madam Chairman. I'm Ron Meyer. I'm here on behalf of Representative Angie Nixon, who responded.
Madam Chair.
Yes.
Madam Chair, I wish to disclose that Mr. Meyer and I are friends.
Okay.
He has been a contributor to my campaigns, but notwithstanding that, I believe that I can be a fair and impartial judge at this one.
Thank you.
And I will disclose that, just like Commissioner Bates, Mr. Meyer is a friend of mine, but he has not contributed to my campaign.
Nor mine.
I'm sorry, Ron.
Started something now.
We have before us a proposed stipulation between the commission advocate and the respondent. After considering all the materials and presentation of the parties, the commission may vote to approve or reject the stipulation. Complainants have the right to comment in writing on the proposed stipulation. I believe we received record of that. Is there a hard copy of that available?
Just wanted to acknowledge the complainant.
I'm the complainant, David Hodges, I am here.
Thank you.
A hard copy of the joint stipulation?
No, did not the complainant submit a written response, which we received in a subsequent email? Yeah.
The response to the joint stipulation.
Yes, it was a response to the joint, we received it in an email. We don't have it on our computer.
I believe I have it.
Okay, you got it? Do you need yours back? Thank you. Oh, okay, thank you.
Yes, Pat?
No, I give it back to the respondent. Thank you.
Thanks.
Okay, thank you.
All right, Ms. Miller, you're recognized.
Thank you. This is a pre-probable cause joint stipulation on a 2019 CE Form 6. The respondent serves as a member of the Florida House of Representatives. There's one allegation, but there are several components that make up that one allegation. Not all of the alleged errors in the complaint have merit. Those that do are as follows. The respondent failed to report a mortgage with North Star Mortgage LLC as a liability. She reported the home that's attached to that mortgage as an asset on her form, but she did not report the mortgage as a liability. The second error was that she failed to report or disclose rental income. Those two errors affected her net worth. She did file an amended Form 6X on or about December 23rd, 2020, wherein she corrected those errors. She added the mortgage as a liability. She added the approximately $4,000 as rental income, and in turn that affected her net worth, which she recalculated. The joint stipulation before you is for $250, and the parties ask that you adopt it.
Thank you. Are there questions of the advocate? Any questions? Mr. Meyer, would you like to?
We certainly urge the commission to adopt the stipulation. This is a circumstance where this young lady is in her first term as a state representative. She has tried her best to faithfully disclose what is required to be disclosed. And for reasons which are somewhat inexplicable, she failed to list the liability of the mortgage on the house, which she did disclose as an obligation. Regarding the so-called rental income, she had a roommate living with her who, from time to time, would contribute money to household expenses. There was no lease, there was no rental agreement, but there was money that came in. Frankly, she didn't think of the house as rental property, didn't think she had to disclose it. I guess we could even argue whether she did have to. The point is she did disclose it in Form 6X so that she was completely transparent. The complainant made a large number of allegations in this case, which your investigator, Mr. Mullally, thoroughly and competently investigated and found that they just simply didn't have merit. What did have merit was she omitted the liability, and she omitted those payments from her roommate, for which she is sorry, for which she has corrected the record. I can promise you, after this experience that she has gone through, including paying a lawyer, you will never find another error in any Form 6 this lady ever files again, because she has certainly been schooled in the importance of doing this right. We ask you to accept the stipulation.
Thank you. Are there questions of the respondent? Thank you. Is there discussion on the joint stipulation? My only comment is I do find the penalty like a flick on the wrist, but I'm going to support it. Is there a motion?
Make a motion. I move to accept the pre-probable cause joint stipulation.
Is there a second?
Second.
Second. We have Commissioner Waldman, seconded by Commissioner Akers to approve the joint stipulation. All in favor say aye. Aye. Any opposed? Show that approved.
Thank you very much, Commissioners.
Is council back for the other matter? Let's go back to case 19-158 in RD. that we have the respondent, complainant, and their counsel in attendance. You've already identified yourself in the record. The probable cause determination is the conclusion of the preliminary investigation. The respondent and the advocate are permitted to make brief statements in the nature of oral arguments to the commission based on the investigator's report, the advocate's recommendations, the complaint, and staff recommendations, as well as any written statements submitted by the respondent. No testimony or other evidence will be accepted at the hearing. Each party will have 10 minutes. The commission advocate will present the probable cause recommendation first, then we will hear from the respondent. If the advocate reserves time for rebuttal will be allowed. Ms. Hadley, will you be reserving your time?
Yes.
And you are, Ms. Hadley, you're recommended.
And I did want to represent that I've spoken with Mr. Hardy and let him know the situation that we're in. And basically where I think that the only place right now that the commission for sure would be comfortable. And he's speaking with family. I mean, there's value, I think, to him since we're in the
I'd like to recognize the advocate at this point, please. Thank you.
Yes.
Respondent served as supervisor of elections for Madison County. He is no longer in office. He is alleged to have violated section 112.3136 by using his position to arrange for the issuance of and/or receiving salary advances above and beyond the statutorily mandated salary of county supervisors of election. Salaries for county supervisor of elections are statutorily determined. Respondent directed employees in his office to issue extra salary payments to him, which resulted in respondent receiving an additional $6,503.96 in fiscal year 2014 through 2015, and respondent receiving an additional $10,436.07 in additional salary for the fiscal year 2016 through 2017. These extra salary payments mean respondent received well over his statutorily mandated salary for those fiscal years. These payments were discovered because unacknowledged. In December 2017, respondent repaid or paid $17,236.20 to the supervisor of elections office, which is $296.13 more than was calculated by the auditing firm. Directing these overpayments was inconsistent with the proper performance of office of respondent, as he asked for and received more than his statutorily mandated salary, which is contrary to Florida law. The salary advance was a special benefit or privilege in that respondent was the only supervisor of elections employee who received advance payments. I recommend the finding of probable cause.
Are there questions of the advocate? The respondent?
Thank you, Madam Chair. Very briefly, I think that some of the points that were made helped illustrate the case. For instance, it was over 2 fiscal years, and his office was audited each year. And the first year, when he took advance payments, there was no audit exception or audit mention that this was improper. It wasn't until the second year where it was mentioned that it was improper, and that's when he paid it back. The other issue, of course, is, if he's going to be accused of theft, it requires a mens rea. There was no effort to conceal what had happened, where the money went. There was no subterfuge at all. There was some things that happened in his life, but that's neither here nor there. He acknowledges that he took the money and he shouldn't have. But I do think it's a mitigating factor that he did not believe that he was stealing. And of course, he's not wrapped up in any aspect of the state attorney that was indicted. He's not involved in that. He was never accused of bribing or anything like that. I mean, I don't know what that attorney did, but it wasn't our case. And so I do think that there are questions as to whether or not the mens rea for theft is present in this case. I'd be happy to answer questions if there are. Thank you.
Are there questions of the respondent?
Just a quick one. If the supervisor of elections took money
from public funds that didn't belong to him. What did he think it was, if not stable?
It was put down as advanced salary. It was tracked, and got tracked of by the bookkeeper. And he thought that he was taking salary advances. As the advocate mentioned, she mentioned that no one else had received salary advances. But he thought it was salary advances. When I mentioned before that he had been told, basically what he had been told was that the Office of Supervisor of Elections budget, he has to run the office, and how he does that is up to him. No one told him to take advanced salary. I'm not saying that, but within the scope or the realm of what he thought the budget, was, and as long as he didn't overtake what he would be entitled to in his term, he would be okay. But it was kept track of as advanced salary payments. He did go through one audit. The auditor didn't mention anything, which, probably unintentionally, I mean, if I missed it, but it served to reinforce the belief, which made the amount greater. A house did burn down, and there are some things that happened. I stress again, he was fully cooperative. He talked to FDLE, I believe, on numerous occasions. He spoke to FDLE. I know he spoke to your investigators. He had never made any effort to conceal anything as a thief would do. It's foolish, but it certainly isn't criminal. Unless there's a mens rea, you probably take something you know you're not supposed to take.
Are there other questions for the advocate, Commissioner Wall?
Thank you, Madam Chair. But in terms of the theft, I guess that's probably why, as Commissioner Meigs said earlier, state attorney didn't do anything. So that's not what we're here for. We're here for an ethics violation, and that's a different standard than I'm talking about. So I get it that you're talking about that, but so why exactly did he do it? I mean, I don't understand. Other than it just seems he did get away with it.
Well, I mean, there were some things that happened, and I'm not sure I understand all the reasons why he did it. I think part of it was lifestyle, perhaps spending more money than he should have, which perhaps lots of us are guilty of. But his house did burn down, and he did have some expenses there. I was just corrected by the co-counsel that he at least believes that the auditor told him it was okay the first year, but certainly it was audited and there was no concession. So we know that they didn't say it was wrong, but obviously a major, an ALJ hearing would be fact-finding. But I only mentioned the criminal aspect because I think that there was some anger on the commission because they thought that this was willfully stealing money he knew he wasn't supposed to take, and that implies sneaking it, and concealing it, and hiding it. None of that happened. I mean, it was wrong. They shouldn't have done it. I'm not trying to justify what he did, but I am trying to mitigate the intent of what he did.
So, I'm not sure. So is it his position that he didn't know that he had taken more money than he was entitled to, or that he?
Well, I mean, to answer your question, he believed that he was taking salary advances, and that he was entitled to his statutory salary, and he became convinced, for a number of reasons, that he was allowed X number of dollars. And because of the way things worked out, and that he was allowed to take that much. He did not believe that he was taking money that he would never be entitled to or wasn't entitled to. He thought he was taking salary advances. And clearly he's not allowed to do that. I'm not saying he's not to do that. I'm saying that he believed he was. And it was kept track of. I mean, there were records to show that he had done this. It wasn't like he turned in false receipts or anything like that.
Are there other questions of the respondent's counsel? Is there discussion? Does anyone have a motion?
Madam Chair, I move the advocate's recommendation for a finding of probable cause.
Second.
We have Commissioner Gates recommending, by motion for probable cause, seconded by Commissioner Grant. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Show that, motion. Thank you. All right, we'll move to rewind, stop here. To item 5, consideration of costs and fees petition. Cases 20-002 in Ray Cunningham. Will the parties or their counsel please identify themselves for the record?
Mark Karen on behalf of Karen Cunningham.
On panelist J.C. Platas on behalf of Mr. Singer.
And just, again, I'm going to disclose that I know respondents' counsel and prior professional experiences. It will not impede my judgment on this matter. Members, we have written materials in this matter. Our staff attorney, Carolyn Planky, will introduce it. After Ms. Planky speaks, the parties will be given 10 minutes of argument. We will then decide whether to refer the petition to the Division of Administrative Hearings or whether to dismiss the petition. Ms. Planky, you are ready.
Thank you. Before you today for your consideration and vote is Mayor Cunningham's petition for costs and attorney's fees filed by the respondent to the underlying ethics complaint, Mayor Karen Cunningham. And the response is also before you to the petition filed by David Singer, the complainant in the underlying ethics complaint. I note that as you just saw, counsel for both parties are here with us today and would like an opportunity to address you. Pursuant to Commission Rule 34-5.0291, if the Commission on Ethics finds that the matter before you, including the petition and the response to the petition, is not sufficient to state a claim for attorney's fees and costs, it should be dismissed. However, if it finds that the facts and grounds alleged in these pleadings state a claim for attorney's fees and costs, the Commission shall direct the petition to be heard before the Division of Administrative Hearings. As you know, the elements of a valid claim for costs and attorney's fees are unique with respect to our process and are set forth within the Code of Ethics in section 112.313, subsection 7. This provision provides that the requirements are threefold: that the ethics complaint was made with malicious intent to injure the public official's reputation, that the person filing the complaint knew that the statements made about the official were false or made the statements with a reckless disregard for the truth, and that the allegations were material to a violation of the Code of Ethics. Case law, including most recently Hadid versus the State Commission on Ethics, make it clear that the statute is narrowly drawn and allows recovery only in very limited situations when all three elements are present. However, in the instant matter, and as reflected in the memorandum which accompanies your materials, staff believes that the three requisite elements do appear to be present as pled in the petition. At this time, counsel for the petitioner and for the complainant are present and prepared to address the Commission.
Thank you. We'll see counsel for Cunningham first. Mr. Aaron.
Madam Chair, members of the Commission, Mark Karen on behalf of Karen Cunningham. May I try to reserve some time for rebuttal in the event that I have some time left over?
Yeah, yes.
Thank you. The staff memorandum from Senior Staff Attorney Carolyn Kleinke sets forth the elements necessary to establish a claim for attorney's fees pursuant to Section 112.3177 Florida statutes and Rule 34-5029 Florida Administrative Code. Ms. Kleinke set those elements out before you in her presentation. I was going to reiterate them here at this time, but I don't think you need to hear it a second time. Mayor Cunningham submits that she has met this standard and requests that the petition be referred to the Division of Administrative Hearings. And in terms of that, I want to point you to the complaint that was filed in this case as described in the determination of investigative jurisdiction in order to investigate, which was prepared by your executive director. That document states, the complaint states that the respondent used her official position and public resources during village-sponsored community events to promote her preferred candidates for elective office and used her private media pages, which were linked to the village's official public media page, to endorse candidates for elective office who are also attorneys in the respondent's law firm. The determination of investigative jurisdiction, again promulgated and written by your executive director, states that these allegations indicate a possible violation of 112.3136 Florida statutes by the respondent. Yet, when it was investigated, when the complaint was investigated, the complainant admitted, quote, that he has no specific knowledge of respondent using her position or public resources to campaign for others, inconsistent with what was in the complaint. The complainant also admitted in the report of investigation that the public event at which Mayor Cunningham appeared and spoke in favor of her friend, quote, was not an official village event, unquote, but instead was sponsored by the League of Women Voters. The complainant conceded that he, quote, is not alleging that the respondent used official social media or public resources via her personal Facebook page to endorse or promote Pelham, as he is unaware of any direct links between the respondent's Facebook page account and any official accounts of the village. Again, inconsistent with what was in the complaint per se. The petition alleges that the complainant, as an elected official serving on the same municipal body as Mayor Cunningham, has been a long political opponent whose efforts to attack the Mayor Cunningham for imagined grievances continue, and there's numerous examples of that. The petition further alleges that the complainant routinely lodges false accusations against Mayor Cunningham with this and other administrative agencies in order to embarrass the mayor and force her to spend time and money responding to baseless complaints. In response to the petition for attorney's fees, Mr. Singer argues through his counsel the following. First, this is the quote, first, even though this is filed as a complaint, Singer asks for an investigation on misuse of office, as opposed to making an actual allegation, let alone false ones. The complaint does not even cite a violation of the ethics laws. I would like to point out to the commission that the complaint did indeed file a complaint. The commission's complaint form CE50 contains extensive and detailed explanations of how to file a complaint, the complaint and investigative process, and the potential for the imposition of costs and attorney's fees. To argue that I just wanted an investigation, I really didn't intend to file a complaint, is somewhat disingenuous. Whether or not, again, in response to the petition, whether or not Cunningham actually used village official social media is irrelevant. That's what's argued in the response. Our response to that is to the contrary. The allegation that the mayor linked to the village's official public media page to endorse candidates for elective office, who are also the attorney's friends in law firm, is noted specifically in the commission's determination of investigative jurisdiction. And the conclusion is that indicates a possible violation of 112.3136. Thus, the allegations are material to this commission taking jurisdiction, investigating it, and finding that those allegations were false. Thus, Mayor Cunningham has satisfied the elements necessary to plead a claim for costs and attorney's fees pursuant to section 112.3137 and rule 34-5.02913 Florida Administrative Code. Specifically, the complaint was made with malicious intent to injure Mayor Cunningham's reputation. The complainant knew that the statements made about the official were false when made the statements about the official with reckless disregard for the truth, and that the statements were material to the commission determining that it had jurisdiction to investigate. It did investigate and determined that there was no probable cause to support the allegations. With that, I close my presentation and would answer any questions.
Are there questions for Mr. Heron? And I don't believe I offered commission questions from Ms. Planky, so if you have for either. Thank you, Mr. Heron. Counsel for Mr. Singer.
Madam Chair?
Oh, I'm sorry.
I just want to disclose also I served in the legislature with Mr. Plannis. I don't believe it will impact on my position. I would agree with me.
Does that make you know that good with this?
No.
Good afternoon, Madam Chair, members of the commission. May I move?
Yes.
Thank you very much. This doesn't rise to the level. The truth is that you guys have a lot of things that come before you where complaints are really filed with malice. You have people who try to win their elections by filing ethics complaints. This was not one of them. Mayor Cunningham was not on the ballot. So there's no proof that this was done to injure any sort of reputation at all. Mayor Cunningham was not on the ballot. This was done way before the election. This was done out of concern. And I'll go from the complaint. Yes, my good friend Mr. Heron is correct. There was a filing of a complaint, but at the end it says request. This is an official request that an investigation be opened. And that tone continues when the investigator calls Mr. Singer, former Commissioner Singer. This is a legitimate issue. A small municipal mayor has powers, and it is a concern if that mayor is using powers to be able to get people that are on her side elected. There was legitimacy to the complaint. The attorney's fee provision was done in order to prevent a gross misuse of the facts or filing a complaint knowing that the facts are wrong on something that's totally out of the ordinary. All commissioners here have seen those complaints. They get wiped out right off the bat, and that's what the attorney fee provision was geared to defend. This was an honest request for an investigation. There was no falsehood. There was no malicious intent to injure a reputation because there was no leak to the press. And I think you guys have all seen complaints that have been leaked to the press before. I certainly have seen them in defending them. There's no disregard. There is nothing here that rises. Now, the petition even mentions 57-105, and I've filed 57-105 motions in civil litigation. That's a high burden. Yes, the statute wants courts to award attorney's fees in the filing of frivolous pleadings, but a concern over a municipal mayor attached with pictures in social media. And nowadays, social media is ubiquitous in campaigns. It is impossible sometimes to tell. And as we all saw from the past election cycle, Facebook has changed the tools because sometimes it is impossible to tell the difference between a personal social media account and an official social media account. That was the impetus of this complaint. Mr. Singer is not the most artful person. He is not, I mean, as someone who gets hired to do complaints, this is not something I would have ever filed like this. But as inartfully as he filed this complaint, it doesn't rise to these three prongs of actual malice, knowledge that the complaint contains false allegations, reckless disregard, and there's no essence in here of any materiality. He's asking you guys to investigate. If you award fees in this, it is going to lower the bar for fees, and it is going to cause trepidation for the next person who is concerned about whether or not their municipal mayor is abusing their position. That person would have pause in filing a complaint, and that is not what this commission wants. We want individuals to have no trepidation whatsoever in seeking an investigation of their elected officials. This commission is what stands in the way. If all of a sudden we lower the bar for attorney's fees, there will be fewer complaints filed, and there will be individuals who probably get away with ethical violations. With that, I'll be brief. If any of you have questions.
Are there questions for Singer's counsel? Mr. Herron, did you wish for both? Thank you.
Thank you, Madam Chair. Thank you, Commissioners.
Just briefly, to remind the commission, your staff had reviewed this and recommended to you that it met all the requirements for referral to DOAH. Oftentimes, staff doesn't do that, and you all know that, and you've seen those petitions before. With respect to, again, the false statements, again, if you compare the statements in the complaint upon which the executive director found investigative jurisdiction with the responses of the complainant in the report of investigation, he essentially backs away from every allegation that is in the complaint, which has been self-styled now as a request for investigation. Finally, there is no requirement that the petition seeking attorney's fees be considered in connection with an election. The elements are, as stated, malicious intent to injure the reputation, knew the statements made by the official were false or made about the official with reckless disregard for the truth, and that the statements were material to the commission's investigation. And there's also no requirement that the complaints be leaked to the press. Again, the only elements are the ones I just outlined to you, and we would ask you to refer this matter to DOAH to determine whether the allegations in the complaint are true and can sustain the basis for award of attorney's fees. Thank you.
Any questions for Mr. Herron on this? Well, is there discussion? Is there a motion? Commissioner Anker.
Madam Chair, I would like to move the approval of a determination that the petition is sufficient and refer it to an ALJ with JOA.
The motion by Commissioner Ankers. Is there a second?
Second.
There's a second by Commissioner Meggs. We already got that?
Yes.
Okay, thank you. Is there any further discussion on the matter? All in, Commissioner Wall.
Just a procedural question, because I don't understand, this is the first time I've dealt with one of these matters. So all we're saying is we don't have the facts, but there are enough allegations there to send it to DOA for a hearing, and then at that point, they'll be able to determine or make a decision whether or not it's risen to that level of violating statute.
This is actually the first hearing I have been where there's been a recommendation for recompensation, so I'll defer to Chris.
If I might, through the chair, Commissioner, all this really is a facial determination of his petition for fees in light of the record and the argument. And when it goes to the Division of Administrative Hearings, it'll be assigned to an ALJ, and they'll have full discovery, and it will be like a civil trial, a bench trial in civil court. And what that will result in then is if it goes all the way through that process and they don't settle in between or something, it'll result in a recommended order by an administrative law judge as to whether or not the petitioner has carried their burden for an award of fees. That recommended order, that could go either way. The judge could recommend that their fees be awarded or not. The recommended order comes back to this commission. The parties have a chance to file exceptions, objections, that is, in a fancy 120 way of saying it, to the recommended order. And then this commission would have to do a review of the recommended order and any exceptions and issue a final order as to whether or not attorney's fees would or wouldn't be awarded. And if they are awarded, then the Attorney General's office helps collect them under the statute, but basically you'll have a trial at the division and it'll come back here similar to a regular complaint matter that's tried at the division, and it comes back here for final action by the commission.
So then, Madam Chair, thank you. So now, essentially, all we're doing is determining whether or not the petition is sufficient to move, go forward at this point.
Yes, sir.
That's just looking at the four corners of the petition, I would imagine. Thank you.
Any other discussion of the motion? All in favor say aye.
Aye.
Any opposed? Show the motion approved. Okay, we're going to move into item 6, advisory opinions. Okay, we'll first move to file 2773, and Ms. Planky, you are, is here as the requester here. Would you state your name for the record?
Allison Rogers, Escambia County Attorney.
Thank you for coming. Ms. Planky, you
Commissioner, the issues before you today is one which arises infrequently in our analysis with regard to the application of the ethics laws, and which focuses on your interpretation of section 112.313, subsection 5. This provision expressly modifies the application of the voting conflict section contained in section 112.3143 to allow for a collegial body member who would otherwise have a voting conflict to vote on matters affecting their own, quote, salary, expenses, or other compensation as public officers, end quote. The purpose of this provision is to negate the gridlock which paralyzes collegial bodies, which are the only entity authorized to make decisions and vote regarding matters setting or affecting their own salary, expenses, and compensation. But the task of determining what is meant by that term, salary, expenses, or other compensation as public officers, is a job of the Commission on Ethics. And a careful, exhaustive review of the doctrinal history indicates that it is always a challenging one, especially in the context of the facts such as we have before us today. The draft opinion arose from an inquiry made on behalf of the Escambia County Attorney and on behalf of a member of the Escambia County Commission. For many years, the county has maintained by county ordinance a 401A local government annuity program for eligible elected county officers and senior management level county employees who have withdrawn from the Florida Retirement System, or FRS, in favor of this option. In the past 8 years, this local annuity option has become far more advantageous for people who have elected this option because the percentage of the employer contribution actually deposited on behalf of participants in FRS programs is significantly less than those deposited in the 401A plans. A review of footnote 4 in your draft analysis gives some particularities with regard to that. However, until very recently, the county's HR department did not inform incoming county commissioners or eligible senior management level county staff of the 401A program or the benefits of this option. And as a result, even though it has existed since the 1980s, only one county commissioner and very few SMS county employees have elected to participate in this option. As a result of this lack of notice at the time that the requester learned of this option during his second term in office, and he attempted to avail himself of the program, he was foreclosed from doing so. As elected public officers must decide to withdraw from FRS by law within 6 months after assuming their public office. When he was subsequently re-elected to a third term, he immediately withdrew from FRS and enrolled in the 401A program. In order to address the issue caused by the lack of notice provided by the county's HR department regarding the program, the requester would like to propose offering a retirement compensation resolution to the class of eligible elected county officers and SMS county employees that would be calculated based upon the difference between the employer's previous contributions to the FRS program and what the employer's contribution would have been had the person elected to participate in the 401A program at the earliest point in which they qualified. The county attorney's office has identified 16 individuals, including 4 out of the 5 county commissioners currently serving on the board, as eligible for the proposed retirement compensation resolution. And therein lies the issue. As you know, the voting conflicts law contained in section 112.313, prohibits in part a public officer from voting on any measure which would inure to their own special private gain. And in the instant matter, it is clear that absent the application of section 112.3135, the requester, as well as the 3 other members of the county commission, who are members of the eligible class, would be presented with a voting conflict regarding the retirement compensation resolution, for which they are eligible, which they would be eligible, because it would inure to their special private gain. However, the commission has previously found in advisory opinions that section 112.3135, which affects the application in the first sentence of the voting conflicts law, expressly permits public officers to vote on matters affecting their own public salary, expenses, or other compensation when such a benefit is derived from their position as a public officer. For example, we have applied this provision in previous advisory opinions to allow members of collegial bodies to vote on the public repayment of their own legal fees and expenses incurred while defending themselves against ethics complaints. We've also held that they can seek and vote on the reimbursement of their own travel expenses incurred in their public capacity, and the inclusion of themselves and their families in a discount on the cost of medical services provided by their own agency, a hospital district. However, the facts before you in the incident analysis require you to determine if the retirement compensation resolution itself constitutes other compensation as a public officer, such that 112.3135 should apply to negate the voting conflict and permit the requester and the other affected members of the board to vote on the matter. Or alternatively, if this resolution does not constitute such compensation in their public capacity, and thus the exception contained in 112.3135 is inapplicable. In such an instance, they would be faced with a voting conflict, one which would be largely preclusive, given the fact that 90% of the board would be so inflicted or so positive. Because the retirement benefits at issue arise solely from the individual's public service as an elected public officer or an SMS class employee, as provided by law and via their own local ordinance, which creates the program, and because the proposed resolution is derived exclusively from public funds to address the inequality resulting from a lack of notice created by the county's own HR department, the draft before you proffers that the retirement resolution would constitute other compensation derived by virtue of their public positions, and thus the provisions of 112.3135 would apply to negate the voting conflict. And the requester and the other members of the board who would be eligible members of the class would not be prohibited from voting on the matter. The opinion then goes on to say that such a vote would not constitute a misuse of the requester's public position under section 112.313 subsection 6, or a prohibited disproportionate benefit under Article 2, Section 8 of the Florida Constitution, as the vote would not be inconsistent with the proper performance of their public duties while serving on the county commission, nor would such a vote be done with a corrupt or wrongful intent required for the application of those respective provisions. But here, I would like to turn your attention to page 10 of the draft before you contained in question 2. And in it, I would like to proffer for your consideration, should this matter go forward, in the first full sentence on page 10 of the draft, I quote, or I largely lifted a statement that was made in an opinion that CEO 91-62. It is as follows. In particular, we find that a vote on a resolution which is consistent with the application of section 112.313, subsection 5 of the Florida statutes, cannot be said to be inconsistent with the proper performance of a public officer's public duties. Should this go forward, I would like you to consider my oral modification to soften that language. At the time that this was adopted, the last sentence of 112.313.5, which is not an issue here, was not yet adopted within the statute. But we have, since the articulation that is contained here, which is accurate, should be further nuanced. And I would like to proffer that after the Florida statutes, citation, section 112.313.5 Florida statutes, comma, a clause be added to say, and in the absence of facts which indicate the presence of a corrupt or wrongful intent, it cannot be said. And then the rest of that sentence. This is, or something of that ilk, or the authority to modify it in accordance with this instruction. Because we have seen since this 1991 opinion that there are instances where a facial 112.313.5 argument may be pled and be applicable. However, in the presence of a surfeit of existing analysis and facts that indicate a wrongful intent, which we've seen in several complaints since the issuance of this opinion, we don't want to foreclose the possibility of scrutinizing them under 112.313 subsection 6, the misuse of public office, or a disproportionate benefit analysis under the new constitutional amendment, which became effective in 2020. However, none of those facts are present here. The requester is, we have asked a series of requests for additional information. They've been very forthcoming and candid, and there's no indication that such facts would occur. But for the future, we just want to make sure that we would not be foreclosed should those facts come before you in a complaint. Staff is available to answer any questions you may have. And the requester and the Escambia County Attorney are here with us and would like an opportunity to address you.
My staff can you, and are there any questions for Ms. Clanky?
Quick question.
Yes.
Madam Chair, in your suggestion as to the, what you call a verbal softening, by the imposition of the corrupt or wrongful intent phrase, are you imposing a higher or new standard that needs to be imposed, given the constitutional amendment that speaks to disproportionate and disproportionate effect?
I use those terms because the intent component that is defined within our rule 34-18.001, which this commission adopted, defining in part the intent requirement, adopts some of that language. And the purpose of this addition is not to impose a higher standard, but it is to continue to recognize, as we have previously, that a 112.313 argument wherein an individual, and I have a illustrative example that I contemplated in suggesting that perhaps a softening was necessary. It involved the last sentence of 112.313.5 that is not implicated here, but involves and allows for people acting as governmental attorneys to consider matters affecting their own salary. We have had misuse of public office investigations based on complaints wherein they did erroneously inflate their own salary when at the time that administrative personnel that had an economic check on their ability to unilaterally increase their own salaries retired. And they did so quite a bit.
Madam Chair, I apologize. Let me try to put a finer point on my question to save time. The whole point of Amendment 12 was to no longer require
a corrupt or wrongful intent, but rather to utilize the term disproportionate benefit. By imposing corrupt or wrongful intent in your phraseology here, do you not revert to the higher standard that the constitutional amendment was specifically designed to lower in order to find that there's been an ethical violation?
That was not the intention.
Could it be the effect?
It is, there are several factors we would consider in analyzing pursuant to the rule provisions that would define disproportionate benefit. We would contemplate there's a mens rea component we would also scrutinize. If you would prefer, my design is only to make sure that in the presence of a 3135 argument, we are not foreclosed from looking at them under the disproportionate benefit constitutional amendment or the misuse of public office.
Thank you, Madam Chair.
Can I clarify, when the term softening of the opinion really is actually tightening the ethics requirements and ensuring this opinion rejects any, even if it's done with corrupt intent, you can't deny it, correct? So the word softening is kind of misleading. This makes this opinion less, or it limits these actions further rather than granting greater latitude if you amend it the way you wish.
Correct. It would not be to the deficit of this agency's ability to scrutinize behavior or conduct that is implicative of disproportionate benefit or misuse of public office, even when the person has a facial argument for the application of 3135.
Thank you, Madam Chair. That helps.
Thank you. Commissioner Walton.
Thank you, Madam Chair. Would your opinion or position be the same if the class was smaller? Because here you have a class, essentially 25% of the class are the elected, are the members voting on that.
The analysis under whether or not the section 112.3135 applies would be the same. The class size is, as long as it is finite. However, it is not dispositive regarding whether or not the exception contained in 112.3135 is applicable. 112.3135 applies to expressly permit and negate voting conflicts to allow members of collegial bodies to vote on matters affecting their own salary, expenses, or compensation.
So, Madam Chair, to follow.
Yes.
So what do you make it, if you're saying that the only 4 people who were affected were the 4 people voting on it, that's still okay?
Yes, and they would still be faced with the same analysis because the analysis focuses on the individuals who are on the collegial body. They are the ones who only have the 112.3143 voting conflicts provisions applicable to them.
And so, Madam Chair, if the proposal were to give the chairman of the Board of County Commissioners a $25,000 in-service education allowance to spend at his discretion and the use of a $50,000 vehicle to drive, and it was only a class of 1 to benefit, under your analysis, it would be proper for him to vote on that.
Under my analysis, we would have to look at those particular facts. But in the past, I mentioned the express ones, the advisory opinions that have looked at what could compensation be. But for example, we've looked at this in terms of a town council member permitting him by virtue of the application of 112.3135 to vote on his own appointment. And the city mayor to vote on the budget, which establishes a higher salary for himself. That's why I mentioned that these are all tough questions because of the exact question that you raised. It can lead to a parade of horribles when this agency doesn't carefully police the boundaries of it But that is what we have to do as the Commission on Ethics.
So, Madam Chair, notwithstanding the caution that you just expressed, you would still answer the question, yes, the county commission chairman could vote on a proposal to give himself $25,000 in education expenses to spend at his discretion and a $50,000 private drive, even if he were the only one to benefit.
Would he be permitted under 112.3135, which expressly allows any public officer to vote on a matter affecting his or her own salary, expenses, or other compensation as a public officer? Yes.
And in your view, the constitutional amendment prohibiting disproportionate benefit to himself or his relatives or his business associates would not trump that?
No, not in the instant case, because in comparison to other members of the class of 16 affected individuals, for which the formula is uniformly applied to determine the benefit that they will in fact engender, if this is approved, then he is similarly situated and is not.
Why do you not hypothetical? A class of one.
Would he have a voting conflict that would require his abstention in light of the application of 3135, which expressly allows him to do this? No.
And so therefore, the fact that he is voting on a proposal that gives him clearly a disproportionate benefit, himself solely and only, in your mind, the Constitution sort of a document among friends?
That would be a careful scrutiny we would apply under this new provision, which has only been effective since December 30th, 2020. We would have to parse those facts with particularity. I can tell you in this matter that there is no indication of a disproportionate benefit or the intent requirement, as it is not inconsistent with the proper performance of their public duties to deliberate these types of resolutions for equity.
Thank you, Madam Chair.
Chris, I wanted to be recognized.
Thank you, through the chair. This goes somewhat to what you were asking, Commissioner Gates, if I could follow up a little bit there. I think what Ms. Clank is attempting to do is the word softening really, I think, is really a hardening. And it's a desire here to not preclude the commission from finding differently on a different set of facts that are more egregious than what is before you.
That was my point.
And these advisory opinions are, the reason this is coming before you is it's a particular set of facts that you need to look at, and it won't legitimize any parade of horribles in the future. And people in the future, if they do abuse their position to get something weird and wild, like some of the things that you mentioned there are just very self-ingratiating and very abusive and very insular and very disproportionate, that's a far different reality than what these folks have put in front of us here in good faith today on this. And this is a really more of a regular benefit type thing of a position. And what she's trying to do, changes a little bit of that sentence, is to leave the door open to get the really bad actors in the future, or to deny a request if somebody comes with an opinion in the future and it obviously is disproportionate and abusive. But it would not appear that that's the case with this one, but she's designed to keep the door open individually for future abusers. And the Constitution is very much going to be a part of that, along with the existing statute that's already been there. They're both not shut by what she's proposing. The door is open to get the abusers in the future. Thank you.
Are there any other questions for Ms. Clancy? Would we want to hear from the requester now?
Thank you. Thank you. Good afternoon, Madam Chairman, members of the commission. I appreciate the opportunity to be here. I can certainly support the recommendation that came from staff, and I would ask that you do likewise. And I certainly appreciate the opportunity to come before you before ever taking any issue up with my agency or my board, to try to get in front of it, to find out an opinion from you before ever having to come before you. So, thank you, and I'm here to answer the questions I can as well as I can. My attorney is here as well. There's some of the communications that she's had with staff that I may not be privy to. Some of the answers I may not know that she may know, some institutional knowledge that I might not have.
Are there questions of the request for? Seems to be none, thank you. Is there discussion on the draft opinion? No discussion, is there a motion, discussion? Commissioner Gates?
Thank you, Madam Chair, and I move to adopt the draft opinion.
All right, is there a second?
Second.
Second, we have multiple seconds. All in favor of Commissioner Anger?
I just want to have a clarification about the hardening of the language. Is that included as a part of the motion?
So of course,
He says yes.
I'll always defer to Commissioner.
I'm deferring to.
Yeah, and given that toughens the standard, that's our understanding, correct? Very good. All in favor of the motion, signify by saying aye.
Aye.
Any opposed? Show the motion is approved. Congratulations and good luck.
Thank you very much.
Next, we'll go to file 2774, which will be presented by Mr. Zilkowski.
Thank you, Madam Chair. This opinion request comes to us from Kirby Oberdorfer. She is the Deputy Director of Ethics and Compliance for the City of Jacksonville. Present here today from the City of Jacksonville is Lasikia Hodges. She is the Deputy General Counsel for the city. She's available to answer any questions that you may have for her after my presentation. Ronald B. Salem is he's a council member of the City Council for the City of Jacksonville. And he is also, in his private capacity, he's a consulting pharmacist. He owns a business. He's the sole proprietor of that business and the sole employee of the business. And in his public capacity as the city council member, he oversees and votes on an annual budget for the city. That annual budget includes appropriations for the Jacksonville Sheriff's Office. The Jacksonville Sheriff's Office, as you know, has people in its custody, and they're required to provide medical services for those people. And they contract with a company called Armor. Armor provides, among other things, they're contracted to provide pharmacy services for the Jacksonville Sheriff's Office. Armor subcontracts to Diamond, a company called Diamond. Diamond, under their subcontract, they provide medications for the pharmacies. Diamond then subcontracts to, or is seeking to subcontract to the city council member's business. Under the law, which is cited in the draft opinion before you, the Jacksonville Sheriff's Office is required to have a consulting pharmacist oversee and supervise its institutional pharmacies and all the jails. Under the, with the Jacksonville Sheriff's Office have institutional pharmacies in them. They need a consulting pharmacist to oversee them. They're hoping, Diamond is hoping to hire the council member's business to be that consulting pharmacist. The consulting pharmacist would do a couple things. He would ensure all medication procedures are followed, and then he would do quarterly and monthly reporting in compliance with the law. They asked whether or not the Diamond's hiring and subcontracting to the council member's pharmacy consulting business would be a conflict of interest or a voting conflict under the law. The draft opinion before you says it will not be a conflict of interest for the subcontract to occur. There are two conflict of interest provisions that are relevant whenever we're talking about conflicts of interest. Section 112.313, subsection 3 says you cannot in a private capacity sell, lease, or rent goods, realty, or services to your agency or any political or any agency of your political subdivision. The Jacksonville Sheriff's Office is not, is not the agent. It's an agency within his political subdivision, but it's not who he's selling his services to. He's selling his services to Diamond. We have precedent, and it's cited in the draft opinion that says
that under a subcontractor agreement, when you're not selling directly to the agency, you're selling to the subcontractor, that's going to be allowed and won't be a conflict of interest. Looking at the second conflict of interest statute, section 112.313 subsection 7A, it says you cannot you cannot have employment or a contractual relationship with a business entity doing business with your agency. And we have interpreted that to include situations where you're also providing licensed services to your agency or to some entity that benefits your agency. This provision of law is not going to be a conflict of interest because his agency is the city council. He's a city council member, and his agency is the city council. His agency is not the Jacksonville Sheriff's Office, and therefore providing licensed services that ultimately benefit the Jacksonville Sheriff's Office will not implicate the statute. The second part of section 112.313 subsection 7A says you can't have a frequently recurring or continuing conflict of interest. There's nothing in the fact pattern that would indicate that that would be present. So again, no conflict of interest. The voting conflict issue is a little bit different. As you just heard, a voting conflict occurs whenever you have a vote before you that will inure to your special private gain or loss, or to the special private gain or loss of a principal by whom you're retained, such as your own business. The contract that is ultimately subcontracted or resubcontracted, and ultimately, if his business is hired to do this work, it contains salary dollars for him. If he votes on anything that would include approval of funds for the subcontract and the salary dollars, including the city's annual budget, which includes the sheriff's office budget, which includes funds for this contract, then that could be a voting conflict because it would inure to his special private gain or loss and would have the salary dollars in there. What we recommend in the opinion is that there be a bifurcation of the vote, and that the part of the vote that contains the sheriff's office budget, that be extricated, and that he can vote on the remainder of the budget without a voting conflict, and that he would abstain from the part that has the sheriff's office budget vote in it. After we published the draft opinion on our website, the requester got back in touch with us and said, well, we can do that, but what we'd really like to do is extricate just the contract from the vote. So he can vote on the Jacksonville Sheriff's Office budget along with the rest of the city budget. The Jacksonville Sheriff's Office budget represents about 36% of the city's budget. It would be great if he could vote on all of that and just not vote on his own contract. It's the same analysis for us. As long as he's not voting on the contract that provides salary dollars to him and his business, it will not be a voting conflict for him. What I would like to do and what I would propose with your approval is that we add, and you would call it a softening or a hardening or whatever you like. But what I would propose that we do is on the last sentence of the opinion, what we would say is, however, the city council member is advised that bifurcating the city budget vote into two separate votes so that he can abstain from voting on the Jacksonville Sheriff Office budget, and then we would add, or any portion of the Jacksonville Sheriff Office budget containing the Jacksonville Sheriff Office contract, which is the source of his voting conflict, will then allow him to vote on the remainder of the city budget. If you have any questions, I'm available to any questions you have. Also, I will remind you that Ms. Hodges is here to answer any questions on behalf of Jacksonville.
Ms. Hodges, would you like to present to the committee? I do have a question for you, actually. Or, yes, thank you. Do you have a presentation for us that you'd like to? Okay.
No, I think
Okay. Is the contract a separate line item in this budget? Or is it just going to be a verbal, oh yeah, I'm not voting on my own contract?
Right. So through the chair, Lasikia Hodges, Office of General Counsel, Deputy General Counsel for the City of Jacksonville. So the Sheriff's Office budget is about, $500 million. There's a professional services line item that's about $24 million. This contract represents about $14 million of that $24 million, and it's a generic line item. So it's not, there's no detail that the council sees on the face of the budget. They can request information from our city council auditors, but that's not any information that's readily seen on the budget. Does that answer your question?
Yes, thank you. Any other questions for either Mr. Zolkowski or Ms. Hodges?
Okay, thank you. Just a few minutes. So good afternoon. As I said, I'm Lucia Hodges. I just want to, as always, take the opportunity to thank the commission for your hard work of your staff. Councilmember Salem is a practicing pharmacist, as the staff said. He's been practicing successfully for over 40 years in Jacksonville, and so we're very pleased with this opinion. We agree with the language. We appreciate, hopefully you will adopt the language that will allow the council member to exercise the other end of the voting conflict, which is a requirement to vote. And so if we could separate out and call out just the portion of the JSO's budget that affects the council member, that's definitely what we would prefer. So on behalf of the council member and the Office of General Counsel, we would ask that you adopt the opinion with the recommended language that your staff just gave you. And once again, we thank you for your time and your effort.
And thank you. And I'm sorry I misunderstood. I thought you did not want to present before us. Are there questions? No questions? Is there a motion?
Move to approve the opinion.
Move the approved opinion as with the amendment?
Second.
All right, we have a motion by Commissioner Meggs and a second by Commissioner Gilzine. All in favor, any discussion?
Aye.
All in favor, say aye.
Aye.
Any opposed? Show the opinion approved as amended. Thank you. All right, we will move to item 7, consideration of order declaring financial disclosure fine uncollectible. And Ray, Lucille, Jello. There are materials which explain this matter. Are there any questions? Is there a motion?
Madam Chair, I move the approval of the proposed order declaring financial disclosure uncollectible.
Is there a second?
Second.
Second. All in favor of the motion, signify by saying aye.
Aye.
Any opposed, show that motion is approved.
Some people do anything to go out there and sign.
Next up is item 8, consideration of rulemaking. We have 2 rules on our agenda today. The purpose of the public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following each of the 2 public hearings, the commission will decide whether to make any changes in response to the public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part, or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission may also make technical changes which do not affect the substance of the rule. Our first rule hearing regarding Rule 37-7.010 of the Florida Administrative Code. Mr. Schaefer prepared the draft, he explained the changes, and then we will proceed with the public hearing and any deliberations and a vote. Mr. Schaefer, you are recognized.
Thank you, Chair. Commissioners, as the Chair said, there's 2 rulemaking matters before you all today. They're fairly straightforward. I'll try to be as brief as I can. The First Amendment pertains to Rule 34-7.010, subsection 1A. That rule sets out and incorporates by reference a form that's been promulgated by the Commission called the Form 2. It's called the Quarterly Client Disclosure Form. The Form 2 is a quarterly form that should be filed by any elected constitutional officer, state officer, local officer, or any other state or local employee with an obligation to file a disclosure form. They have to file it during a particular calendar quarter they've represented a client for a fee or commission before an agency at their level of state government. And there's 2 changes that I'm proposing be made to the form in this rule. First change is very straightforward. The rule and the form currently reflect their statutory authority as found in section 112.3145, subsection 5. But back in 2019, the legislature amended section 112.3145 and its subsections were renumbered. And Steve Zolkowski actually caught this last year. Because of the change, the statutory authority for the form is now found in section 112.3145 subsection 6. So this first change just simply updates the statutory sites in the rule and on the form. The second change that I'm proposing is to update the form to reflect this commission's reasoning in a recent advisory opinion, 20-8. In that opinion, which you issued last fall to a city council member, you found he might be tempted to compromise his public duties if he were to represent a client before a subordinate city board or staff member, inasmuch as he could be tempted to use his influence as a member of the highest governing board of the city to coerce or influence some action for his client's benefit. And because of that, you found he was prohibited by the second part, the section 112.313 subsection 7A, from personally representing that client for compensation before subordinate city staff or board member. Now, I will propose including a sentence in the Form 2 warning local officers serving on governing bodies, like a county commissioner or a city council member, that they could trigger a violation of section 112.313 subsection 7A if they were to represent a client before a lower board of their subdivision. Otherwise, a local officer unaware of that opinion, who happens to be serving on the governing board, might feel that by filing the Form 2, they have covered themselves and they're absolved of any potential conflicts of interest in the Code of Ethics if they go ahead and represent that client before subordinate staff or board member of their city or county. So those are the two proposed amendments to this rule. They are highlighted in yellow on the Form 2 in your meeting materials. I have submitted these changes to JAFC. As of yesterday at 5 o'clock, they did not provide me with any feedback, which I take to mean that they're comfortable with these proposed amendments. So I submit them now for your approval, and I'm happy to answer your questions.
First, this is a public hearing on the issue. Is there anyone here from the public who wishes to speak to the rule?
No.
No? Okay, very good. Are there questions of Mr. Schaefer? Do I have a motion? Is there any discussion on the proposed rule? Do I have a motion?
I'll move it. Move it, accept it.
Commissioner Waltman moves the adoption of the rule. Is there a second?
Second.
Second by Commissioner Grant. Next.
Next.
Next. All in, is there any discussion on that? I'm sorry, did I miss a piece?
No, if I might, just, I think the technical language for the motion that probably ought to be stated is that what's being voted on is a vote by the commission to, and tell me if I'm wrong, Greg, to file the proposed rule as you have it drafted with the Department of State for adoption.
That's correct.
Okay.
Is that what I said?
Sorry to be redundant.
No, we appreciate that, Chris. Thanks very much. All in favor of the motion signify by saying aye.
Aye.
Any opposed? Show that motion approved. The next issue, Mr. Schaefer, you're recognized.
Thank you, Chair. This next rule hearing concerns Rule 34-7.025. As a part of the Commission's rules about ethics training. Certain public officers, as you may know, have to receive 4 hours of annual ethics training pursuant to Section 112.3142. Rule 34-7.025 reminds them of that 4-hour obligation and it lists the areas they should aspire to cover in the ethics training. Last year, the legislature passed a statute having the governing boards of commercial service airports also receive 4 hours of ethics training. They wrote a new law that's not found in Chapter 112 of the Code of Ethics. It's found in Section 332.0075. It is very similar to, but it's still separate from the 4-hour training requirement found in Section 112.3142. This new statute in Chapter 332 applies just to the governing boards of commercial service airports, requires them to get 4 hours of ethics training, and it goes on to say the training should cover Article 2, Section 8 of the state constitution, the Code of Ethics, and the laws about open meetings and public records. And it says if a member of the governing board of a commercial service airport happens to hold another position that already obligates them to get 4 hours of training under 112.3142, that completing the 4 hours of training under 3142 will also satisfy the new training required by this airport board training statute. What I'm proposing this amendment is just to include language in our rule tracking 332.0075 and notifying airport board members that they also have to receive 4 hours of ethics training. Otherwise, they may look at our training rule, not see their position listed there, then feel they have no training obligations. Also, the amendment encourages anyone providing training to an airport board member to apply to the Florida bar so that airport board members who are attorneys can get 4 hours of CE credit. As the other proposed rule, I submitted these changes to JAPSI. I haven't gotten any feedback from them. I submit this now for your review. There's one small change that I noticed. You proofread these things time and time again before you submit them to the administrative register, but inevitably something has slipped through the cracks. I was looking this over earlier this week, and I noticed that I, by mistake, included a parentheses, one parentheses around the phrase code of ethics.
Hello.
It's a
There you go.
But you know, I will make sure to correct that for us for adoption. I don't see any problems with doing that. So.
Or is there anyone from the public here to speak to this rule?
No.
No. Are there any questions? Is there a motion to have this rule sent to the Department of State for adoption? Is there a motion?
I'll move that.
Thank you, Commissioner Waldman. Is there a second?
Second.
Second from Commissioner Akers. And I presume your motion includes the parentheses.
Yeah, that's what you ain't
Yeah, we
sure.
got a horrible omission. All in favor, say aye.
Aye.
Any opposed, show the motion. Thank you. Thank you. Next up is the issue on the consideration of our executive director. Chris has handed me a note from Commissioner Carvajal, which I will read at the appropriate time. I wanted to preface this discussion simply by saying what is before you is simply a proposal. I worked with the executive director to develop an open process by which the commission could seek its next executive director. It involves the pieces before you are an advertisement, a very generic position description that accompanies this position with the legislature, some additional criteria in order to limit the number of applicants to make it manageable, and that we're not going through a variety of applications of folks who are clearly unable to do the work, a timeline and an organization of the commission, so folks need some understanding of how that is staffed. I'd like to read what Commissioner Carvajal has sent. He says, due to scheduling conflicts, I'll be unable to attend the public session. I do plan to participate in the executive session. As discussed last week, when he and Chris spoke last week regarding item 9 on the public agenda, I'm happy to assist in any way with the selection process and will defer to the chair assignments or not. Also, as discussed, you may represent that I support the Commission's interest in public posting and maintaining an open and transparent selection process, though I hope we have safety valves which allow us to evaluate and move to recommend candidates to interview and hire quickly if there is, in quotes, probable cause to believe we only have a few that have the background required for the position, especially familiarity with laws, rules, and procedures of Florida ethics. No matter what path my colleagues choose, there is little doubt in my mind our staff will be able to manage affairs fairly and efficiently through a protracted process. Moreover, I strongly believe that the public's interest and integrity of our work will be maintained through this search, and such is the professionalism commitment of our team and systems and the refreshing collegiality and nonpartisan nature of the commission. Thank you, Mr. Carvajal. I did want to open it up. I'm hoping that those documents were fairly self-explanatory. I don't want to go through the process of what was the thinking in there. It is a proposal, I don't feel wed to, much of any of it, but I did want to put something out there so that we could proceed in doing the impossible, and that is replacing Chris.
Madam Chair, do you have, is there an extra hard copy around?
I'll get one for you, Commissioner. I'll have it here.
I have a question. Is there anything by law that says we have to advertise the selection process and follow any particular statutory process, or is that something we're doing voluntarily?
That is something we're doing voluntarily. We could not do that, and that's historically what's been done.
I think, first of all, I think the description of the position is very well done. I couldn't find any area that I'd want to improve on. I think you and Chris put obviously a lot of work into that. I think it's very explanatory, it's very accurate. But I think before we move to adopting a posting program, I think the commission ought to at least discuss whether we want to consider an internal promotion and selection process without having to go out to the outside. As you point out, there are very few people that could really match the description that you put together, because very few people, if any, outside have the background in ethics legislation, and especially in our project, is a humongous one to provide for electronic filing, all of this that's going on. I guess we ought to have to ask, do we feel that we ought to go outside before we determine whether or not we might have someone inside?
That's certainly up for discussion. I know I have very strong feelings about that, but I'll certainly entertain discussion points from other commissioners. Commissioner Mannix.
Well, I did a little looking back. Apparently this commission was formed in the Askew administration, and our first executive director was Larry Gonzalez, who served for a period of time, and then after him was Bonnie Williams. And I was growing up along about that time, and so I remember Bonnie Williams and the job that she did. I don't know where she came from or how she got the job. But then Philip Claypool, who was our general counsel under Bonnie Williams, became the next executive director. After Philip Claypool, we used Berlinda Doss, who I think was an advocate at one time with the Attorney General, and then worked at the division of the Ethics Commission. And then we were blessed to have, well, he was highly trained because he used to work in the state attorney's office.
We consider that a blip in his.
Well, he was trainable though, and he just did a great job, and has done a great job. I think we're making a mistake, and I want to just y'all indulge me just for a minute. I think we're making a mistake with this commission because our history is we have everybody that has been on here has been internal so far. And I just wonder why we need to change that at this time. And I say that with this thought in mind. I was a board member. I don't know how that happened, on the National District Attorneys Association. And we had we were called the America's Prosecutors. And I represented Florida on that board. And we had an executive director that caused a little problem. We ended up discharging that executive director. And then we hired another one, and he did a great job. And then we advertised, after he wanted to leave, he was retiring, he wanted to leave. And we advertised all over the country, and we got tons of applications to be, because all of these people are experts in their field. They're all executives, and they're all of those things. And we ended up hiring a person that immediately, and as I read this job description, it says hiring and discharging of employees. One of the first things, we had two ladies that worked for the National District Attorneys Association. They knew the organization from the inside, upside, downside, from one end to the other, and any member of the National District Attorney, if you called either one of those ladies, they knew your name, they knew who you were, they could answer your questions, and I could give you several stories. This new executive director, one of her first actions, which we could do nothing about because of the bylaws and because of the rule, is fired the two ladies that knew more about it than anybody else in the organization, and hired an independent travel agency to handle all of our conferences and all of our things. The end result of that is we had a lawsuit. That agency ended up suing the National District Attorneys. Your rooms were always messed up. The conferences went to hell in a handbag, and everything just was fouled up. So I think we're making a mistake when we have someone in the office that knows the office, respected by the employees in the office, works and knows this system, and we have a history of doing something entirely different. So I think we're making a mistake. I don't believe there's a requirement that we advertise by either a rule or statute. If there is, if somebody has one, we can see it. But I just don't think we need to do that, and I think we're making a mistake to do that. And the bottom line, my last thing, and I'll hush. The last thing I will say, we all come and go.
That's correct.
You know, I'm sitting here looking at 4 people that weren't here when I first came on. Then I got fired, then I came back. We come and go, but this staff, and when we see what this staff does for us as a commission, getting us prepared for these meetings, giving us the stuff, you call anybody on this staff, you get an answer, you get something done. And, you know, I have to have computer help periodically, and I would just hate to see someone come in that doesn't know these people and has got to learn these people when we have someone here that knows these people and knows this organization, that has been with the office, with this commission for over 20 years and has served admirably. And we're going to go out and try to find somebody else to come in and be the boss. I think it's a mistake. With that, I'll stop.
Thank you. Are there any other comments? Commissioner Walden.
Thank you, Madam Chair. I'm not going to go as in-depth as Commissioner Meggs did and Commissioner Grant, but I'm in agreement also. I'm a very big believer in hiring from within, succession planning. I think those are the best people that you have. And especially, and I think the point at the end is very well taken, we come and go. And what we do need is consistency and somebody who understands the whole process already and has performed. So I'm in agreement with the 2 other commissioners at this time.
Commissioner Gates.
Thank you, Madam Chair. Madam Chair, I want to first thank you and Chris for your work on this document, which is an excellent document. I believe, I think just like all of us, I've been on all kinds of public and private boards. I think the way you've laid this out, you know, is understandable. It's not overcomplicated or over bureaucratic. And I support what you have put together. I do have a couple of questions. First, as to Commissioner Meggs' point, I think he's right that it's a big mistake to assume that just because you go outside, things are better. And that's one of the reasons why I think the approach that you've taken, Madam Chair, allows for internal candidate or candidates to apply, for them to bring their advantages of understanding the organization, understanding the law, understanding the people, to bring that into an interview and to give a very good account of themselves. I think an inside candidate, if I may say so, has a real leg up in an organization that is as dependent upon an organizational structure and culture and set of laws and rules that this one is. So I think we get the benefits that, that Commissioner Meigs is laying out by not only allowing, but encouraging inside candidates. But I don't think we lose anything if we throw the net a little wider once in a while and see where we wind up. We may wind up with 2 or 3 candidates that are worth looking at. I think the real issue here is in screening and making sure that you don't have everybody who needs a job, everybody whose boss got beat in the last election, everybody who thinks they've got a friend on the commission showing up. And I think the screening process is critical. I see here, unless I misunderstand, Madam Chair, that that you have staff pre-screening applicants and classifying those who clearly meet the qualifications. I would assume that you, as a member of the advisory committee or search committee, hopefully chairing it, if there is such a committee, would have an informal provision in place to make sure that you don't have, in effect, staff screening staff, because that just would be inappropriate and maybe unfair to a staff person who, who might not get along with somebody who's screening them. So I'm sure you'll take that into account. I would ask these questions for your consideration. First, in terms of advertisement, are we looking in the first instance at Florida candidates? Are we looking at American candidates? Are we looking at the Milky Way? How wide a net does your proposal here contemplate you would throw?
The proposal is a rather wide net. Certainly, I would support someone who knows that the additional criteria says that they have 3 years of government ethics law. If the commission would look at Florida ethics law, that would be, I think, fully appropriate given what this commission is. But right now, as it stands, it just requires government ethics experience. The advertisement would be on Online Sunshine, typical to all other legislative advertisements. And, right now, the timeline is actually short, partly to give notice, give opportunity, but not let it hang out there to attract a lot of folks. And to your point, I fully, and I think I said when I brought this issue up last time, I strongly encourage internal applicants. This idea is in no way to reflect badly on any of the staff here. I just believe in an open process and a recognition that there are many talented people, some who have a lot of experience with this commission, some who might come, represent clients for it or who've been prior staff to the commission that may be just as qualified. But right now, to answer your question, anyone could apply and they would have to have 3 years of government ethics experience and 3 years of commission or committee experience.
Ma'am, may I ask one more question?
Absolutely.
I noticed a wide-ranging salary.
Yeah.
And in that context, that I asked this question. I also noticed that in the qualifications, in the draft qualifications as they stand, a background as an attorney is not required. And we have good fortune to have Chris as our executive director and general counsel.
Yes.
I've sort of kept track in today's discussion and the last meeting, the number of questions we've asked him that have required him to answer as a lawyer.
Yes.
Not just as executive director. And most of the questions he's been asked, he's had to rely on his training and his skills and qualifications as a lawyer to answer, not just as somebody who happens to direct our staff. And so my question then becomes, if we aren't going to require that the executive director be a lawyer, then it would seem to me that the implication is that we would have a general counsel. And that would have some implications budgetarily. Now I'm in your world, Madam Chair, but it would seem to me that as you look at the budget of the commission, which I've never seen, to the best of my knowledge, and we look at the salary range, that there are some real issues here. If you hire a very highly qualified individual who could command a very high end of the salary schedule, but that person were not a lawyer, then you would also have to look at the rest of your budget to make sure that you've got the other half of Chris Anderson, given the kinds of interchanges that we have here on the commission table. So I just wanted to ask what your thinking process was there, ma'am.
Yes, and I'm glad that you asked that question. The range for the executive director is simply the range for that position. It's a generic position description. The intent would probably, unless there's some extenuating circumstances, to offer the position at what Chris is earning. With respect to his experience as a lawyer, to me, part of the position's range value is exactly what you said, that ad hoc, immediate ability to jump in, note when we may be jumping off a cliff and save us and bring up issues about case law or whatever it may be that are legal issues. I have experience, and maybe you've encountered some people who have that sort of knowledge base, and they may not be lawyers, but they did sleep at a Holiday Inn the previous night, and so they really know their stuff inside out. I'm not opposed to requiring a law degree, but that was sort of the thinking. And I will say that value to me is, of course, we don't see a lot of the things that go on behind the scenes, but that is, for me, a very important asset that the successful candidate should have.
And Madam Chair, I wasn't lobbying for a lawyer as executive director. I was pointing out what I thought might be, among other things, budget implications.
Yes. I agree. Any other discussion, Commissioner Cummings?
Thank you, Madam Chair. And, maybe I'm too fresh out of the House of Representatives on board with Clay County, but I was taught it was ingrained over those 8 years, never vote against the chair,
Especially this one.
But exactly, but no, in all seriousness, I know at my last meeting, which is my first one, we spent a lot of time on this, on whether we advertise or not, knowing that, there's a very strong candidates or candidate internally. But we all came back to the spirit of what we do here and transparency and just going through a process. I think you can really look at this as a validation where we very well may end up, and it's my guess probably will end up with a strong internal candidate that future commissioners can look at and say, hey, this just wasn't an easy route or an easy process that those commissioners at the time went through to select the executive director, and hopefully would allow that person to continue to succeed, much like our current executive director and the talent team. I think Commissioner Meg nailed it, that I haven't been here long, but my experience that it's not just one person, Mr. Anderson. You've got I haven't seen one that's not extremely talented and strong in every role they do, and no matter what role they do, you've got a lot of leaders in their respective positions. So. I think everybody's made a lot of great points. If some of this, not to get into salary, but I know there was a number mentioned, if that's what you're paid, Mr. Anderson, which I'm sure I could look it up or see, you're probably a little underpaid, to be honest, because, you've got a lot of responsibilities and so forth. So I think y'all done a great job. Obviously, open any discussions to tweak it, but, I'll definitely will support the advertisement, knowing that, there's probably a strong chance we'll wind up, but I think it'll be a much more pure process. And while we couldn't go wrong either way, I appreciate what you're advocating for, Madam Chair.
Oh, thank you. Is there any other commentary? Yes.
I'm not going to repeat what I said before because said. And I agree with Commissioner Meggs, but, you know, I'm not going to be upset if the majority of the commission wants to advertise, because that doesn't include our coming back to make an internal promotion. I just want to raise a procedural question. I don't know how you can have interviews, or maybe not go to interview. I don't know how you can have resumes screened by staff when I suspect there will be one or more staff people who apply. And I think that's a real procedural problem. You know, normally you hire somebody outside that's talented to do that. We don't have the money to do it with the budget. But you know, I think we need to find some way other than having staff evaluate applications that include staff, maybe even their own boss.
And I'm glad, Commissioner Gates, you had asked that and I had forgotten, but I'm glad you asked that. What the process would contemplate, and Chris and I discussed this, and of course, subject, we could not have any screening at all, but to forward all applications to the board that, or the subcommittee that's suggested here, and have these comply with the requirements, these do not comply with the requirements, these are in an iffy situation. Because to me, those requirements, they are not subjective, they are objective. And there are going to be those instances where you're going, does this experience really count or not? But that should be fairly rare. To counteract the notion of a staff person excluding someone would be why all of them go to the commission or the subcommittee of commissioners that will do the interview. If that makes folks uncomfortable, I would recommend that we eliminate that.
Well, Madam Chair, another thought would be that if you have staff members apply, which I hope will be the case, that you as our chair would be the one to screen those applications for conformance with our criteria or not.
That would be fine with me as well. Are there any other comments? I do have some. I wanted to put forth very clearly that we are the Ethics Commission. I will say, and I have heard from others, that this should be an open process. And I've not heard from others who are interested in applying. I've heard from others external to the process of the appearance of the way this commission has selected its executive directors to not be transparent. And I see no reason why it should not be transparent. I will tell you, when I was a new commissioner, the last executive director came to us with one name. Turned out to be an excellent name. It was Chris Anderson, but it was the only name that was brought, considered, and discussed. And it was a sort of very quick vote. I felt uncomfortable, and I should have done something that I did not do at the time. We did not have the opportunity to explore, look at. Many of the commissioners were new, as was myself, and I think that's a disservice to the commission, and most importantly to the public and to the commission itself. A point I wanted to address something that Mr. Meggs said, and Chris, I thought I had read, I may be wrong, that although the job description talks about hiring and firing, I believe we wrote somewhere this is that authority is actually granted the executive director statutorily from the commission to the executive director, so that if that authority wanted to be changed, it could.
If I might, through the chair, you know, I've done this in practice, you know, hiring and unfortunately having to let a couple of people go. But my understanding, even before I had the current position, was that the commission hires the executive director, and then under the uniform legislative type things of a unit of the legislature, and also the independence of the commission, that the executive director hires and fires everybody else. And there's never been any, any bad faith vendetta or anything on people. But I have, when I have hired people and when I've had to let people go, I've never consulted with the commission about it. And I don't think any previous director ever had either.
Right.
That once they are chosen, and they're like other unit heads, and as the chief person hired directly by the commission, they have that authority to operate without having to go ad hoc to the commission on any particular hire or termination.
Okay. Yeah, and thank you. Anyway, I welcome and encourage the participation of staff. I too find the staff to be excellent. I've been very pleased with Mr. Anderson. There is just some discomfort in proceeding that way and having this commission of all commissions doing things in a less than transparent mechanism. And for that reason is why I put forth the idea to advertise. Commissioner Silsey.
Thank you, Madam Chair. I just want just a little more clarity on Commissioner Gates' point earlier. Knowing that our current executive director technically holds two roles, the executive director role and general counsel, is the intent then, if we hire the executive director to Commissioner Gates and they don't have the general counsel, well, that means the general counsel will be hired by the executive director moving forward. How would that work?
Well, and I think, Chris, our previous executive director was also an attorney. You at the time, were you the deputy and the general counsel?
Yes, ma'am. And if I might, through the chair, elaborate just briefly. Like before I became executive director, I was the deputy executive director, and I was also the general counsel, even though Ms. Doss, who was the director, happened to also be an attorney. Now, when I was first hired by the commission many years ago, the executive director was Bonnie Williams, who was not an attorney. And with no disrespect to myself or any of the other executive directors, I think Ms. Williams was probably the best director that the commission ever had. And she was not an attorney. And when I was hired, Mr. Claypool was an attorney, and he was the general counsel. And so it has flip-flopped around. Sometimes the ED is an attorney, sometimes they're not. The general counsel can be the deputy executive director, but they don't have to be. What happened with me was I came on as a staff attorney, and then I had different title changes like chief assistant general counsel or whatever, and moving up from the lawyer position. But usually there's just been a massaging of title and responsibilities within the legal cadre of the commission, and there hasn't necessarily been the need always to create a whole new position or have a giant budget hit for something new. There's ways that that's been massaged. Sometimes you got to get a new person because you need a slot to fill. But generally, the general counsel function has been an elevation of somebody that's been on the staff. They'll get a raise and they'll get more duties. When I was general counsel, I carried a regular caseload, but I also had supervisory responsibility and also some things as deputy director. But it's not like there's any magic to the director having to be a lawyer or that necessarily having been the history. And like I say, Ms. Williams just functioned stellar, and she was not a lawyer. And frankly, I appreciate lawyers. I am one, but I sometimes, it took me for a while to understand that when you're not an attorney and you're the head of an agency, sometimes you have a clearer ability, if you're a smart person, to get the good out of your lawyer that's working for you better than if you try to second guess them. Just to borrow a Civil War phrase, Abraham Lincoln didn't try to second guess his generals and he won. Jeff Davis was a West Pointer and he was always second guessing his generals and he lost. So sometimes that not having that particular skill and being more arm's length with your lawyer when you're a non-lawyer executive director or other agency head, can actually be a strength.
So, following on that, because you are a lawyer, if we selected someone who is not a lawyer, who may not have some of the legal knowledge that you have, but whose other strengths override that, would we need to hire a general counsel? In your opinion, would we have what we need there so that during a commission meeting, someone would come to the rescue?
If I might, through the chair, like when Ms. Goss was director, even though she was an attorney and very skilled at that profession, and this was mainly when we were meeting in the court, you know, when you first got on, and otherwise we had the other room over there. And I'd sit down kind of on the front left. She would almost, once in a while, she would answer some legal things herself, but quite often she would defer to me for the legal position, and there's lawyers that could be deferred to here for any legal question, and I used to do it quite readily. You know, she would say, well, what do you think about that, Mr. Anderson, or the chair would say it. And so as long as you have attorneys on staff, you're not, I don't think, missing that legal knowledge. I don't think so.
And I did want to follow up. I did remember correctly, within the statute actually gives all hiring and firing authority to the commission, not to the executive director. That can be delegated by law. So I wanted to point out, because Commissioner Meggs, you put out a scenario where an executive director was reckless in their terminating behavior, and I think hopefully we wouldn't make a choice like that. But if we did, we have the authority to come in, remove that authority, and take on that activity ourselves. Not that that would be ideal, but it is under the purview of the commission itself relating to hiring, promotion, demotion, termination of commission employees shall be made by the commission, or if so delegated by the commission by its executive director. So that is something that we have a safeguard should we see some bad behavior that you're concerned about.
And Madam Chair, if I may, you know, like probably maybe all of us on the commission, I've been CEO of both private and public organizations. And in every case, I either worked for a board or with a board. And, you know, the best way to kneecap a CEO is to come in and say, well, you know that person you want to hire or fire? No, we're going to have a vote at the meeting on Tuesday, and we're going to tell you you're not. Might as well fire them.
Right.
But there is the informal, which is to say real way that those things operate. When I was CEO of a school district, independently elected, I never fired a principal without sitting down with the chairman of the school board and saying, Rodney, you know, here's what I'm up against. Could I get your advice and counsel? You know, have you got some other thoughts here? Because I wanted to make sure I had his advice, but also I wanted to make sure I covered myself. And I think the same thing could apply and should apply here without having any kind of formal redelegation, which would kneecap a new executive director. I think whoever one hires needs to have that kind of conversation with the chair. And the chair says, you know, welcome to Florida. Glad to have you here from Indiana. But you know, before you do anything significant with staff or personnel or budget, let's talk. Here's my phone number. Here's how to reach me. You know, I'm available. Let's be partners. And I think that kind of informal relationship will build between our chair and our next executive director, be they an inside or outside person. But I would hope we wouldn't go into it with the notion of changing a delegational authority.
Absolutely not.
I know you didn't say.
No, my point in that is that part of why Commissioner Meggs just wanted to pick an internal person is because of a scenario where a board chose an executive director who went out and unilaterally fired people, and it resulted in lawsuits. And I would say if that happened, there would be recourse. But no, I I do not want to be in the position of this commission hiring and firing. I know the headaches that involves, and I would want that to be under the purview of the executive director, as it is now, in consultation with the commission chair. So absolutely.
I would just comment that eventually that executive director of the National District Attorney's Office was fired.
Okay.
After she had just about destroyed the agency and the morale of the agency, and most of the people that were there that had any knowledge. I mean, I can just give you one example real quick. I get a call when I was state attorney, wanting to do some expedition from Canada. We had a prosecutor from Canada that always attended our board meetings. I couldn't remember what his name was. So I called the office of the National District Attorneys Association. One, they didn't know who it was, which got us off on a bad foot. They didn't know who it was. I said, well, who is the prosecutor from Canada? They had no earthly idea. So fortunately, one of the district attorneys in Virginia had hired the great person that she had fired. So I called her over in Virginia and talked to her. She knew the name immediately, had his phone number, gave it to me, and I made contact. That's what happened to us in that situation when we advertised, and we got this genius who could work with the legislature and everybody, and ended up she couldn't work with anybody. So, that's why I just look at the history here. Everybody has come from within, starting with the very first one, Larry Gonzalez, I think.
Any other comment, Commissioner Wong?
Thank you, Madam Chair. And I wanted to be clear, I think it's important that we be transparent, but I don't think we can be any more transparent than we are here discussing this at this point. So the fact that you go out for a nationwide search doesn't make it any more transparent, and it doesn't make us an ethics board that's any better. What we have an obligation to do is to get the best person who can run the organization. Just because that person is already here doesn't mean, or potentially is here, doesn't mean we have to go and search everywhere else. We know what's involved. Now, I can sense certainly there's not a desire to stay just internal and saying to somebody, okay, well, you'll apply. I always found when I was a city commissioner that the person who, a lot of people don't apply because they look at it and they say, that's really already fixed, because the person who's in the organization is going to get the job. So they don't even attempt to do it. And in a sense, it's worse, because then you really haven't gotten anything else. I just believe that in any organization, I see it in my business where I am, I look for the people who are there, who can rise to that position and to do it. It's encouraging for them to put years in at the job that they want, that they know that they have a future. And when you say, okay, all of a sudden, there's always the experts or all those other people who are going to apply, other people out in Colorado who are going to apply, or Illinois, or whatever. You think, oh, well, they're experts, but many times, the people who are the best are the ones who already operate within the organization, know everybody, know the players, are here. This is a very small town, Tallahassee, and it's important that people understand the nature of this place and this board. I just think, basically with what you're doing here, if you are going to do this, you can't really come up with a list in a month. I mean, the timeline's not realistic as I see it. To expect that by April 16th, we're going to have a person that we're going to select to do this. I imagine all of the meetings have to be public, right? So all in the sunshine, correct?
Yes, and there's a procedure by which there would be a group, and just to respond a little bit, how is it that we know we have the best person unless we ask out there? There are lots of persons out there who have been intimately involved, if not staff on the commission before, or who have intimate knowledge of ethics law, so we don't know until we ask. Having the process, I do agree that timeline could actually be more flexible. We don't need to have someone in place until September, I believe, that's Chris has finished in August. I proposed a quick one because I do think it's unsettling when, in a period of uncertainty, but certainly there is more room to move, and I'm very willing to do that. As to transparency, yes, this does create greater transparency, but opportunity and openness and consideration of all qualified folks, I think, is appropriate. And for us, again, it's not like people are going to apply and they're not going to be seriously evaluated for their suitability for this commission. I am proposing that a body, an advisory committee of this commission itself, make recommendations back to the commission. So, hopefully we would entrust ourselves to pick someone who is best suited and very potentially an internal person.
So just to understand, so all of the interviews are all going to be public, so it's everything's going to be done Zoom with this,
yes.
and so
Yes.
so interviewing, so the committee is going to interview in that public meeting. Is that what the plan is?
That's correct, that it proposes a Zoom meeting, or, you could have a in-person meeting where there's also a Zoom capability for an interview to be conducted that way. And I think the proposal is a couple of days of interviews with potential adjustments, given some schedules that may change, or that we don't need 2 days if we have too few that are selected for interviewing, or what have you.
If I might just want to respond to yours where I said we have best. I actually, because I've heard everybody speak very highly of Chris, and I had an opportunity. My view is based upon the person who's in the job now, who has the best knowledge of somebody who would be the best person, the best candidate for here. So I take it from Mr. Anderson and his suggestion that he made last time, believing that he knows, has a very good feel for what would work, the person who would be best for the commission. So that's where it comes from. But certainly, there could be other people out there, but when you do have something already, I usually like to go with that.
Madam Chair, I yield to Commissioner Lincoln.
You'll be glad we did.
I always am.
I'm just kidding. Although I will say that I make poor decisions when I'm hungry, and I'm about 2 seconds from this can of artichokes and this fork to get me through the next few minutes. I think that I'm very conflicted because, like all of you, I have 100% confidence in internal candidates, and I think they have a lot of momentum going into this process that I support. And if I had to vote on one of them specifically right now, I'm quite certain how I would vote would be positive. But as I was doing my push-ups yesterday and hating them, I was thinking in my head, that's short-term pain for long-term gain. Get it done. And I'm beginning to feel that way about this process, that we go through the short-term pains of advertisement for 5.5 weeks, we then will have an executive director on the other side. And I like the aggressive timeline for all the reasons that have been expressed, and I think we can meet it with a lot of energy to the issue. Most importantly, and this is why I said Commissioner Gates might be glad he did, is because he's a vote counter, and you can look around this room and determine we may be split. If you include the input of Commissioner Carbajal, there are at least 4 commissioners who feel strongly, I think, about the advertisement process. And so I'm not so interested in counting votes on advertising or not advertising. What I am interested in is counting votes in the confidence that all commissioners, all respondents, all complainants, and all of the public has in the person ultimately selected for the job. And I believe that the person who has been through the advertising process, who is selected, will then have, in 6 weeks, more credibility, more trust, and more confidence simply because they have been a part of the advertisement process. And for that reason, I request that we move forward with the expedited timeline. I would suggest that we further narrow the scope of the search by adding familiarity with Florida laws, and that we move forth with 3 to 5 people who raise their hands right now who would like to serve on that commission, and I would make that all part of one motion.
Second.
Yep.
And that I not be one of those people, that's part of that is part of my motion.
Okay, we have a motion before us. I don't know that we have 3 to 5 hands, but I think we can get to that. All in favor of that motion, say aye.
Aye.
All opposed? Show the motion approved. Now, are there people who are willing to serve on an advertisement committee? I know I would want to do that.
I'll do
I've got 1, 2, 3, 4 of us. I know that being uneven would be ideal, but I'm good with.
I'll back off and yield to Senator Graham and Commissioner Gelson.
I'm sorry?
I will back off and yield so the.
I think 4 is fine. I think we'll be able to work out our differences, so there will be 4 of us.
For chair, always put the person who's not here on it.
That's why
And
he's
he,
not
I mean,
here.
that long letter he wrote, I think he'd be disappointed if he wasn't on it.
That's right. That's why he wrote the long letter, so that he wouldn't have to be here and couldn't get appointed. Okay, and I do appreciate moving through this and your motion, Commissioner Akers, but we still have to go back into executive session. So with that, is there any other issue regarding this? Oh, and we do want to, on the Florida laws, are you talking Florida laws or Florida ethics laws?
Florida ethics laws.
And you want that
Thank
as a
you.
requirement?
I think that it should be part of the criteria
Okay.
that,
So the criteria that currently says 3 years of experience of government ethics laws should be changed to 3 years of experience of Florida ethics laws. Is everyone in agreement with that?
Commissioner Walden has a good point.
Ethics and sunshine, right? Talking ethics and sunshine.
Not
We don't really deal with
that guy has to do with sunshine.
It's not, I mean, that's not the.
You deal with every meeting you have.
But that's not the expertise that we require. Yes. Okay, I will refer the rest of the organization of all of that to Mr. Anderson to reach out and to follow the timeline that has been set forth. Let us proceed, if I can sign back in. Okay, we are now on to reports. I don't have one. Legislative update. All right, Ms. Stillman. And if you could keep in mind, I think there are hungry.
We're all hungry.
Hungry, angry.
It's going to be very brief this time. I gave you a written report, a couple things that happened since I written report. So just very quickly, House Bill 853, Representative Roy, sponsored, was heard in the Public Integrity and Elections Commission yesterday afternoon, and it passed out of that committee unanimously. It's significant in that it contains some of the recommendations that you all made. First of all, it contains the closure of the conflicting employment loophole that was recommended. So I know you get excited about that. Second of all, it makes changes in the voting conflict law. Your recommendation was to make state and local elected and appointed all the same. This bill doesn't go quite that far, but it does get to where I think you thought we might be able to get, which is making the local elected officials have the same voting conflict requirements as appointed elected officials, or excuse me, as appointed local officials do, which is the elected local officials would now have to disclose their conflict prior to any participation on a matter. So that is in the bill as well. What also is in the bill is something related to the enhanced financial disclosure, where your recommendation was to have city elected mayors and city commissioners file a Form 6, same as constitutional officers, same as county commissioners and the like, making the same level of transparency amongst those officials. This bill revisits that fluctuating standard that they talked about and passed in the House the last few years when they dealt with financial disclosure. What it is that any municipality with revenues of 10 million or more for the 3 fiscal years prior to the filing year, their city commissioners and elected mayors would file Form 6. If subsequent to that, their city had less than 10 million in revenue, those officials would fall off the Form 6 list and go back on the Form 1 list. And then we would have to see it for 3 consecutive 4 fiscal years. They got to the 10 million mark and then they would file Form 6. This is something that the commission has not been a fan of in the past because it makes things more complicated for the filer. It's more confusing for the filer. Which form do I file? If you're switching forms from year to year, if you filled out a 1 and filled out a 6, you know they're very different forms. In terms of transparency for the public, they would lose sort of the ability to do a longitudinal analysis looking at some of these disclosure forms because they'd be looking at forms year after year. And not insignificantly, it does complicate things for your staff in terms of implementation, particularly in light of e-filing that is coming up. Probably in excess from the numbers they said, more than 250 municipalities with revenues of 10 million or more. We will have to look at a spreadsheet and sort of manually figure that out year after year. I reached out and Chris reached out to the bill sponsor. He was great, his staff was great. Also talked to Don Grubauer, the staff director for High Committee. We're going to continue to work with them on the language. And I did indicate that although they, as a policy standpoint, might like that fluctuating standpoint, the fluctuating standard, but the commission standpoint is that it should be that uniform Form 6 for those local city commissioners and mayors. It has no companion bill in the Senate, no similar bill in the Senate. It has 2 more committee stops. In terms of the Senate, we do not have an ethics bill in the Senate that Chris and I have been able to find. I know we had language in bill drafting. We have not yet seen anything in Senate, so this bill may be our vehicle to move across the Senate as we go through legislative session. There could be some PCBs that come out. Have not yet heard what those might be. The other bill that I wanted to mention is House Bill 1365 and Senate Bill 1756. They amend Chapter 99 and 106 as it relates to qualifying for running for election. But significantly, they amend 112.324 and prohibit, the Lincoln bill currently would prohibit a person who has a probable cause finding from being able to qualify to run for office. The commission would have to notify qualifying officers that this person has a probable cause finding on them and that they are unable to legally qualify to run for office. The person could run for office once the commission had made a final determination. In other words, dismissed under RUD. If you took final action and there was a stipulation, if you took final action and there was a recommended order. I noted that although it says they couldn't qualify if they had a probable cause finding, it does not prohibit somebody who's found in violation from qualifying to run for office. The probable cause is the hook. We would then have to notify all the qualifying officers if somebody no longer had a probable cause finding on them because you took final action and you either found somebody in violation or not. Those people would still be able to run for office. Chris and I talked about it. He certainly believes that there are some potential constitutional issues with the bill. And we've talked about that a little bit, and we'll be reaching out to legislative staff and sponsors. If this passes, certainly in addition to the running for office and qualification for running for office, it's going to put some pretty high stakes on the probable cause considerations that you all make here. It's already a clear and convincing standard. There could be, I could see net effects of a probable cause determination limiting somebody's ability to run for office, really raising those stakes. Also putting a lot of pressure on this agency, potentially politically, which is not something we've dealt with before, to free people up to be able to run for office or not. So it's been assigned to 3 committees in the Senate and 3 committees in the House. And if you all have any direction on that bill or 853 that you would like to pass on to us, for us to share, or if any of you would like to get involved in those efforts, we would welcome that. And finally, on your list, there was one bill that dealt with fiduciary duty of board members, and after additional research and reaching out to legislative staff, we're going to take that off your list of concerns as written. It would not apply to the commission. And I'm available for questions and direction.
Thank you, Carrie. Are there questions, Carrie? Is there any comment or discussion? I would like to bring up the idea for the commission to oppose the notion of disqualifying people running for office on a probable cause finding. We already know that we see the commission used as a political tool from time to time, and I find that highly disconcerting. I don't know if anyone shares in that. I guess not.
Madam Chair, do you want a motion?
I wanted to know the will of the commission or the thoughts of the commission.
Well, to dispose of it one way or the other, I move to have the commission go on record and communicate to both houses our opposition to House Bill
1756, I believe it's
1756.
Senate Bill 1756 and House Bill 1365.
Yeah.
On that issue.
Yes, please.
Thank you. Is there a second?
I'll say it.
Second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Show that adopted. Thank you, Commissioner Gates. All right. Thank you. Any other questions for Carrie? Thank you, Carrie.
Okay.
Okay. Yeah.
Just briefly on e-filing, we're currently testing functionality and the look and feel of the system. Data migration is our next big thing for us. It's a significant thing. It's going to be taking place probably in about a month or so when that starts. That will be the most significant factor at this point in a go, no-go decision for a January 1 launch. It is likely the next time we meet in April, I will know the answer to that. In the meantime, many hours of work, lots of high-level implementation meetings with Bob Enders, Senate IT, and Scott McPherson in the House about these issues, but we are moving along with the notion of the January 1 launch, but stay tuned.
Thank you, Carrie. Thank you. Chris?
Thank you, Chair. Just briefly, you have my written report, which shows all the different particular matters that the governor imposed penalties on, and I checked on the governor's website, and they're up there as executive orders. And when you go to the governor's website, you'll see executive orders, and underneath there's executive orders again. And I think we probably had so many that they had to have a different thing for us. But anyway, the good news is that most all of the things that have been transmitted to the governor's office, he has now put the penalty on people. In addition to that, I hate to say that Charlie Fields, he's been an investigator with us. He's taken a new position in another county, but Charlie, we wish you well. Stand up if you would. Hope everything goes well. And of course, not that I believe in this thing about matter and antimatter and there only being a certain amount of energy in the universe, but when we lose his energy, we gain more energy. And Matt, if you stand up, Matt Garrett is our newly hired investigator. That's all I have.
Okay, very good. And we already disposed of the last item first. So is there any other business in the public session? Commissioner Waldman moves that we adjourn the public session.